Particularly against Kyoto.
Sino?
Hearing. I am a veteran of this business. Your Lordship may consider keeping a raised platform.
That is what
On which this is too little minutes. This should be raised.
But then I thought, I can't see the lawyers as well.
That's a small price to pay for what your Lordship will gain with this. And your Lordship may be missing nothing much. Because this flat raising, I keep a flat raising on that, it helps a lot. Because otherwise your Lordship is bending down.
And you have to, otherwise you have to keep your back straight.
And you have to bend down in any case if it's not raised.
No, raising means half of you are vanished from my screen. That's the problem.
I think all of us, but on that side of this, we have these postural issues.
This is an occupational hazard. The old vintage. Well, so the second part is, the positive and negative injunction is not only factually wrong and has caused the change of government. That has caused, I made that argument earlier, but it is juristically wrong. That's the second consequence your Lordships should rectify. Only Supreme Court can do these rectifications. Nobody else can. Well, it's really futile to have a whole ladder again starting some High Court, the ladder going all the way to Supreme Court. It really is futile. Nobody can touch. These are Kyoto, these are Navam Rabias. Therefore, third is the consequence of the governor's direction for a floor test. Well, there is no way in which the governor can interfere like this, especially in a case where disqualification is sub judice or pending.
The consequence of the governor's direction for a floor test.
Floor test in a pending disqualification matter. Sub judice at two levels, sub judice at your Lordship's level, sub judice at the Speaker's level. It's a double sub judice. He's after all deciding in a quasi-judicial capacity there. As a tribunal.
Sure. Okay.
There is this third point, this third aspect can be rephrased juristically in a different way. Whereas your Lordship is dealing with a legislative issue primarily. Executive has no role to come into it. Laterally, sideways, the executive can't enter it. The governor is, though a constitutional post holder, an executive appointee. So this third aspect is really the executive direct lateral entry into a no-go area. Totally impermissible. That's a consequence your Lordship alone can rectify, should rectify. That applies to all these consequences. Somebody else will decide. It will be a partial decision. Supreme Court, for the polity, for constitutional morality, for the whole system, must decide.
This is part of your third point only.
This is under consequences, C. First point is consequence, ABC. This is the third one. The fourth one is, Bullets. It is distinct, but it relates to the governor. The governor recognizes a split. Well, if your lordships can't do it, governor will do it. The Supreme Court with 142 today, if a judgment is passed under 141, 142 saying we recognize a split, your lordship would be acting contrary to law. The governor can do it. Directly recognizes in writing a split with great respect. Here there is inbuilt double whammy. The governor is an error as a constitutional holder, and the executive is coming into and recognizing. The central government executive is coming in and recognizing a split. Now that letter, your lordships may not have seen for some time now, maybe in the beginning it was shown. Just turn to that letter, for a minute. Para 7 of the PDF, compilation 2, 326, correct? PDF 326, compilation 2, dated 28th June 2022. This is very important. This. A constitutional amendment promoting the constituent parliamentary intent to do away with split is collaterally recognized by an executive appointee governor who has no locus, which the Supreme Court can't also do.
Compilation of, there are
CC2 of
There is a number for each document.
CC2 it is called, right? CC2 of the document is not the case law.
Convenient
326, convenience 2.
326.
326 is the PDF page. It's the governor's name on 28th of June. In that volume, it is serial number 5. In that volume.
The volume is called serial.
Oh, I see. The volume is called serial number 5. My apologies. Whereas your lordship, it just takes.
P4. Annexure P4.
no, what is it?
Yes, sir. We got it.
I see. My lord doesn't have it, perhaps.
Convenience.
My ladyship has got it.
Yes,
My ladyship has got it.
yes, please.
Dear Shri Udhavji, the governor writes to the chief minister. I am going to emphasize para 7, but I'll read 2 and 3 also, leading up to 7. It's para 7 I want to read, but I'll just read 2 and 3 for backdrop. I am in receipt of a resolution dated 21/6, signed by 34 members of Shiv Sena, legislature party, stating that there is enormous discontent within the Shiv Sena cadre and the electorate on account of alliance with NCP and INC. The resolution clearly indicates that the majority members of Shiv Sena legislature party want to exit the alliance with NCP and INC, and to that end, they have reaffirmed the appointment of the leader of the Shiv Sena legislative party. I am also in receipt of a letter of 21 June addressed by Mr. Shinde to the Deputy Speaker, stating that the purported appointment of one Ajay Chaudhary is illegal, having been made by 16 MLAs without notice, without quorum, therefore the same is inoperative. So this the governor is saying, because the governor can hardly at all interfere in any of these subjects while disqualification is pending at 2 levels. But that apart, leave 2 and 3. Now come to 7. Well, how can the governor say this? Kindly read 7. Is it possible? Forget the right or wrong. Why should the governor say it? How can he say it constitutionally is my question to myself. It is thus clear that a majority of the Shiv Sena MLAs have given a clear indication on behalf of the Shiv Sena legislative party that they intend to exit from the Maha Vikas Aghadi government, and that you have been made aware of the same, and that you are trying to win over your MLAs and cadre means not democratic. I am therefore confident that you and your government has lost the trust of the House and the government is a minority. I'll just pause and look at let's just forget this case for 2 minutes. Look at the consequences of this letter in the constitutional and the juristic sense. Number 1, it is a certification by an executive nominee that the departing allegedly disqualified members, allegedly by me, are kosher. They are not disqualified. They are not disqualified, is his confidence. Number two, that you, Mr. Uddhav, is not the Shiva Sena, but those people are. He's writing to Uddhav Thackeray. Three, he is doing it under the nose of a pending disqualification, then scheduled proceeding, and a hotly contested Supreme Court matter. The ordinary mortals who are doing it, Lord should take a very serious view. I know Lordships can't issue directions to the governor and content may not lie. But just consider, Manoj, if anybody else would write a letter like this, when your Lordship is hearing such a heavily contested matter and the Speaker is dealing with it, I don't know, Manoj, normally, Manoj, we'd expect some contempt notice. Then some appropriate case will also examine how far the arc of immunity applies. Number four, he is, Manoj, actually setting up the ground as a precursor. Come to me, I will swear you in. This is an advance intimation. This seventh para read as it is can only say, come to me, I am ready to swear you in. Because you are kosher. There is no problem with you, there is no stigma. Only step left is that nothing is left. Therefore, Malaj, to the other question, my lord, the Honorable Chief Justice asked me on Thursday, Malaj, what is it that you want us to do in the event that we agree with you? Lordship put a question like that. One of the simplest levels, of course, I gave you Lordship a larger answer, simplest levels to quash this letter. Now, suppose your Lordship quashes this letter, just for a minute. And I do not press, except for one or two things, in any meaningful way for other things. Just suppose, I'm just not conceding anything, I'm just giving the Lordship a supposition. The status quo ante is automatically restored. Lordship doesn't have to say it. And is that constitutional morality? Is that fair play? Is that upholding the greatest traditions of governance? Because clearly it is. And certainly, there can be no bar, immunity, hesitation, legal obstacle, constitutional bar from quashing this letter if your Lordship otherwise agrees with me. This letter is not a non-quashable document, Manoj.
It's directly impugned.
It's a direct prayer, directly impugned in all the writ petitions or many of the writ petitions. Take it, Manoj. Take it that it's impugned. I don't know if you should take out the prayer. No, not from here. So, now, Manoj, this is the fourth consequence. The fifth is a obvious consequence of this consequence. Next step is swearing in, which happens on
30th.
30th. This is 28th, 30th. In fact, the seeds of that are very clear in para 7. I told you it's an advance intimation. It happens 2 days later. So that's a letter saying you are kosher. That is what is acting on the letter and giving you a constitutional status of a minister. Well, in fact, I'm sorry, that swearing in was the chief minister. 30th was the swearing of Mr. Shinde.
Chief Minister, 38.
So you are swearing in a constitutional head of state. And what is the last consequence is again consequential to the consequence, which is appointment of the speaker. If I may say the new speaker or the speaker.
Thank you.
I have given a lordship 6 consequences. I mean, one can make probably 7 or 8 also, but let's say 6. Well, as my respectful submission is, A, that these are serious consequences, extremely serious for our constitutional polity. B, they are case neutral to the present case. They are extremely serious for our constitutional polity. B, they are case neutral from this present case. They are juristic questions and they are bound to recur unless your lordship plugs the loophole this way or that way. Third, these are all within your lordship's judicial domain. None of this is a no-go area. Fourth, and this is very important, fourth, only your lordship, I'm not saying your lordships may, I'm saying only your lordships can decide and should decide this. I'm not even making an optional rule. According to me, this is only the Honorable Supreme Court which can and should decide it here, not delegated to any other authority. Then, this is the main point, really. And then, of course, it follows that your lordship would, as an ancillary, because your lordship passes ancillary.
Anything else now remains?
Says, it's just 2 minutes more. Well,
and
your
at
lord,
the end, I have one question, but I didn't want to disturb your
no,
lordship.
I'll just take about 10 minutes more. I'm going to make some. So, your lordship will therefore restore, in the ancillary sense, the position as on 27th or such date. That is, ultimately, your lordship's orders are not spurics. They have to have an effect. That effect has to be only that restoration.
To restore position as on
27th August, June. That is, this is 28th, so 27th is 1 day before. Now, coming back to my note, and I'll be very quick with that's written down. Come to para 12. This is the other facet. Your lordship stopped at 12:13 last time. Just come to para 12 of my note.
Where you
convenience
A3, the one your lordship were using.
are?
Now, what is the point? And I'll be very quick with this. Purposive interpretation in 10th schedule legislature cases, your lordship is repeated many times.
Which page, Dr. Singh?
Para 12 of my note, page 5. This is that A3 note. Oh, I see. It's page 7. Page 7?
It's 7.
In your lordship, it may be page 7.
Yes.
Now, purposive interpretation, what was this new fashion? Of course, now it's old. Bennion calls teleological approach.
Yes, got it.
It is for
Para 12 commences by saying it is further
Respectfully submitted that the above course, the next line is purposive interpretation.
Right.
Or your lordship calls it teleological approach. One of the most abstract books, follows that Bennion, very difficult to read. Now, let us just see, what is that purposive interpretation? These are the principles. Why does your lordship talk of the evil of political defections? Next para. Now, it will be very brief. Quixote quoted, well known to your lordships. Quixote in para 4 cites the statement of objects and then says this, I am reading, the evil of political defection has been a matter of national concern, not combated, likely to undermine the very foundations of our democracy and the principles which sustain it. With this object, an assurance was given in the address by the President to Parliament that the government intended to introduce in the current session of Parliament an anti-defection bill. The bill is meant for outgoing defection. Why are you saying all this in Kyoto, which is 20 years ago, 30 years ago? It's 30 years ago. Because this says that when you interpret anything in this area, you must push this sentiment, this object. That's the object of this. Next, Jagjit Singh. Just see this, fellows. Jagjit Singh, all the citations are given. I'll not go to it. I'll just read it from my notebooks. The validity of the orders by the Speaker under 2.2 disqualifying certain independent MLAs of Haryana 3 days prior to the election for the Rajya Sabha fell for consideration. Lordship knows in the Rajya Sabha the MLA's vote was. This Honourable Court rejected an argument that the Speaker's order had been passed in haste, observing that the disqualified MLAs were interested in prolonging the disqualification proceedings beyond the date of Rajya Sabha. Critically, it was held that an independent MLA cannot be permitted to avoid the consequence of defection merely by not completing the formalities of joining a political party. So this was not, this was only by purposive interpretation. This was extending and stretching, if I may use the cruder word, stretching it, but stretching it for the purpose of promoting this object. Of course, it's an irony. There, you did it to, well, they said we'll prolong the disqualification so he can't vote. I said he can vote in the Rajya Sabha. Here, well, it's the same man as the Chief Minister. If Jagdish Singh is right, well, this is a 10 times a for sure case which we are arguing now. That was only a Rajya Sabha election. Now 29 is what the Supreme Court says. It is also essential to bear in mind the objects, underline the word objects, for enacting the defection law, namely to curb the menace for defection. Despite defection, a member cannot be permitted to get away with it without facing the consequences of such defection only because of mere technicalities. The substance and spirit of law is the guiding factor to decide whether an elected member has joined or not joined a political party after his election. It would not be a validity, etc. I'll skip that. Now see Rajendra Rana, Constitution Bench, well-known case. But it was decided on the basis of purposive interpretation. There were gaps. Your Lordship had to fill the gaps. Your Lordship resorted to purposive interpretation. Kindly see that. This Honourable Court rejected an argument of the initial defection by 13. So this is a two-part defection. Initial was 13. Followed by a subsequent claim by 37 MLAs that there was a split in the BSP in terms of para 3 meant that there was no disqualification of the initial 13 MLAs. Now, this is the good old days of a split existing. Even then, look at the way Your Lordship interpreted it. Your Lordship had the split existing, but see how you interpreted it. By purposive. The court applied the principle of purposive interpretation to hold the disqualification occurs on the date when the acts attracting disqualification are committed. Therefore, the question of disqualification, whether there had been a split, had to be determined with reference to the initial date, not the subsequent date. Thus, the defense to the plea of disqualification cannot be a subsequent defense and must have arisen at the time when the acts constituting the disqualification were committed. Now, just read two marked portions. I will not read the whole one. If Your Lordship permit me, the first 6 lines of 33 only. It may be that the collective dissent is not intended to be stifled by the enactment of 1022. But at the same time, it is clear that the object, mark the word object, is to discourage defection, which has assumed menacing proportions, undermining the very basis of democracy. Well, the very basis of democracy comes close to basic structure. Democracy has been held to be basic structure already, obviously. Therefore, a purposive interpretation in para 2 in juxtaposition of 3 and 4 is called for. Therefore, then one thing is clear, that defection is the ground for disqualifying a member. He incurs the disqualification when he is voluntarily given a membership of his original political party, meaning that the party on whose ticket he got elected. In the case of defense of a whip, I'll skip that to save time. Come to the next marked portion, next para, the highlighted portion. The fact that a decision in this regard may be taken in the case of voluntary giving up by the Speaker at a subsequent point of time cannot and does not postpone the incurring of disqualification by the act of the legislator. Similarly, the fact that the party could condone, could theoretically, there's a para which allows you to condone, the defiance of a whip within 15 days, or that the Speaker takes the decision only thereafter, cannot also pitch the time of disqualification as anything other than the point at which the whip is defied. I'm not only arguing relating back, I'm arguing purposive interpretation, apart from relating back. Relating back is arrived at by adopting purposive interpretation. Therefore, in the background of the object sought to be achieved by the 52nd Amendment and on a true understanding of para 2 with reference to other paras, the position that emerges is that the Speaker has to decide the question of disqualification with reference to the date on which a member voluntarily gives up his membership or defies the whip. That is arrived at by purposive interpretation, no other way. It is really a decision ex post facto. The fact that in terms of para 6, a decision on the question is to be taken by the Speaker or the Chairman cannot lead to a conclusion that the question has to be determined only with reference to the date of the decision of the Speaker. An interpretation of that nature would leave the disqualification to an indeterminate point of time to the whims of the decision-making authority. Same would defeat the very object of enacting the law. Whereas by disabling notice to a speaker, you will achieve the same. By the speaker, the governor writing letters will achieve the same. All these are nullifying the 10th schedule. That's why purposive interpretation is vital. Your Lordship has separately noted with me paras 12, 52 and 53 of Rana. That is done in the earlier department argue. That's not quoted here. Now, Srimant Balaji Patil, Balasaheb Patil, in para 89, which is quoted, just come to the boldface alone to save time. So I'm skipping long paras in between. If we hold that the disqualification proceedings will become infructuous upon tendering resignation. Now, this is another technique, Malas. Because Malas, if you are disqualified, then Malas, you have to fight an election again to become a minister. Well, if you are disqualified, you must fight an election again to become a minister. So people will just resign and then immediately become a minister. Then you get 6 months to be elected. You can become a minister now and need not be elected for a while. So to get around that, this is Malas, your Lordship's purposive interpretation. If we hold that the disqualification proceedings will become infructuous upon tendering resignation, any member who is on the verge of being disqualified would immediately resign and would escape the sanctions provided under 751, 164 and 361. These are remuneration consequences and also most importantly that you have to, you can be a minister but be elected within 6 months after that. That is not available if you are disqualified. Such an interpretation would therefore not only be against the intent behind the introduction of the 10th schedule, but also defeat the spirit of the 91st Amendment. Then, Malas, DTC, an inhibition under the Constitution, this is of course not a defection case, but on the principle of purposive, an inhibition under the Constitution must be interpreted so as to give a wider interpretation to cure the existing evils. Now, this is important, even though it's not highlighted, just read this para, 118. Legislation, both statutory and constitutional, are enacted and true from experience of evils, but in general language should not therefore be confined to the form that evil had taken. Time works changes, brings into existence new conditions and purposes and new awarenesses of limitations. Therefore, a principle to be valid must be capable of wider application than the mischief which gave it birth. It was born for reason X. Today, our Lordship will expand it to Y, tomorrow to Z, because we learn from experience, brothers. As they said, brothers, not spirit of law, not logic, but experience. Those famous words of Holmes. This is, therefore, a principle to be valid must be given wider application of the mischief it gave it birth. This is particularly true of constitutional constructions. Constitutions are not ephemeral enactments designed to meet passing occasions. These are, to use the words of Chief Justice Marshall, designed to approach immortality as nearly as human institutions can approach it.
Between the two अगर करना है मान लो नहीं और एक सेकंड कह रहे तो है
Yes, sir.
The last two lines above para 91 in my note, which is para 16 at the end of. In the application of a constitutional limitation on inhibition, our interpretation cannot be only of what has been, but of what may be. My Lord has got that para?
what is here?
Well, within 16, I have quoted judgments. In the quotation, there is a para 91, 2 lines above 91.
Yes.
Then, Wallace, next 91, I will not read, your Lordship has it, one is coming out of your Lordship's ears, this judgment, 5 days your Lordship heard this. Only one sentence I am emphasizing, which was not relevant for the other case. I mean, I didn't argue it there. This is a quotation, Wallace. Last line of 284. The courts must adopt such an interpretation which glorifies the democratic spirit of the Constitution. I'll skip Wallace. Whole of 17, I'll skip. 18 is a very important paragraph, but I have in a different way covered it factually. It includes an overlap with the consequences argument. All the facts are itemized there. So I'll skip it to save time. 18. My Lord has seen my 18. You should just keep it as a factual summary. Now come to 20. Allowing the disqualification petition to be decided by a person who has been appointed as speaker with the active support of the respondents and who has conducted himself in a biased and malafide manner would result in incentivizing the constitutional sin of defection. That's the phrase I want to comment for Lordship's consideration. Incentivizing the constitutional sin of defection and would be against the spirit and intent behind the 10th schedule. The same would be the teeth of constitutional morality. Thus, the principle of purposive interpretation demands that the present speaker not be entrusted. This fellows ends the purposive part. Then para 22 is fellows an interesting point and not merger. Just see the irony here. Your Lordships has only one defense, fellows, apart from condonation of merger. Merger is the supreme irony in this case. Merger is not even alleged by them, claimed by them, raised by them. In case of a merger, suppose 8 out of 10, 6 out of 10, 9 out of 10 leave, the remaining chap left behind is protected. Under your Lordship's 10th schedule is protected. Otherwise, he's a loner. He would himself be, he's protected. Here, but for your Lordship's interim order, which we argued just a few days ago, I'm not protected. Without claiming merger, I mean, today they are issuing letters and whips, which, I'm not talking about Lordship's protection. The whip is being issued as we speak, in various matters, they are entitled to, if the EC has recognized them. But for Lordship's protection, I would be liable to be disqualified for not following his whip. Because without invoking merger, without getting a merger, there is no protection. They become the party. These are consequences. This is a consequence Lordship added in my 6 consequences. This is a very weird consequence. It's a very weird consequence. If you have the defense of a constitution, you are worse off. If you don't take the defense of the constitution, you are better off. I should have mentioned in the consequences list, Lordship will consider putting it there. It's an absolutely absurd, weird consequence. Then, Manas, I have extracted para 4 in para 23, that is para 4 of the 10th schedule. And I've made this point in para 24 again. And therefore, Manas, I have ended with this. I'm ending my submissions with one, Manas, judgment which I have to cite. That's an absolute end, Manas. That's an interesting judgment on, Manas. Where is it found? Where is it found?
3F.
Compilation of judgments,
3F.
volume
3F.
3F. It's a judgment called Indore Development Authority 2028 SCC 129.
Constitution.
Constitution bench.
On restitution. On restitution.
Yes. Your Lordship is a party to it.
Restitution, no?
Restitution. Because that's the fifth facet or sixth facet of setting right a wrong. Well, you call it actus curiae, your Lordship will not allow your Lordship's acts or judgments to harm a party. Your Lordship calls it a situation created by your Lordship's order, etc. Another facet of saying the same thing is restitution. And my Lord is absolutely right.
Which page you want to read?
This is in this volume 3F at PDF page
1 minute.
33.
1 minute.
Starts with
33 is the PDF page of volume 3F. And the citation of Indore development is 2020 8 SCC 129.
33.
33.
Para?
So the first para I wish to read is far away in the beginning. It's para 335 at page.
Oh, 335.
Yes, 335.
At page?
At page
275.
PDF page 275. Mark it now. May I read it, brothers? The page of the PDF is 275.
Yes.
My lords have got it. The principle of restitution is founded on the ideal of doing complete justice at the end of the litigation. I emphasize the word complete justice and I emphasize the word restitution. And parties have to be placed in the same position but for, I said the but for test, but for the litigation and the interim order. These are very, very important words on the Constitution bench. But for, that's the test. But for the litigation and interim order, if any, passed in the matter. In southeastern coalfields, it was held that no party could take advantage of litigation. It has to disgorge the advantage gained due to delay in case the list is lost. The interim order passed by the court merges into a final decision. The validity of an interim order passed in favor of a party stands reversed in the event of a final order going against the party successful at the interim stage. Section 144 of the CPC is not the fountain source of restitution. It is rather a statutory recognition of the rule of justice, equity, and fair play. The court has inherent jurisdiction to order restitution so as to do complete justice. This is also on the principle that a wrongdoer should not be perpetuated. Sorry, wrong order, not wrongdoers, wrong order should not be perpetuated by keeping it alive and respecting it. In exercise of such power, the courts have applied the principle of restitution to myriad situations not falling within the terms of 144. What attracts applicability of restitution is not the act of the court being wrongful or mistake. So this is apart from actus curiae or an error committed by the court. The test is whether on account of an act of the party persuading the court to pass an order held at the end is not sustainable, resulting in one party gaining an advantage which it could not have otherwise earned, or the other party having suffered an impoverishment. It's very well put. I would commend each word of this. Litigation cannot be permitted to be a productive industry. That is only a fond hope. It is a productive industry. Litigation cannot be reduced to gaming, where there is an element of chance in every case. If the concept of restitution is excluded from application to interim orders, then the litigant would stand to gain by swallowing the benefits yielding out of the interim order. Then they quote, I will not read the quotation. Just pause here for 5 seconds. I get an interim order. The interim order is obviously not confirmed. If the interim order is confirmed, the matter doesn't arise. It is other way around. But every consequence of the interim order is enjoyed, gorged, eaten, and then you twiddle your thumbs and say, tough luck, now the final order has come too late, you can't ask for restitution. That is what your lordship seek to address by this passage. It's rather well put. For saving of time, I'm not reading. I would request my lords to read Eastern Coalfields, from where it draws strength. It's a constitution bench. And Mullahs, this is the essence of justice. It's the essence of justice. In a constitutional matter with such grave consequences, it is even Mullahs A for sure. I'm very deeply obliged.
Just one question I had, I mean, it's a facts part. You said, you know, and both Mr. Sibal also said the same thing, that this is not a case where a trust vote is called when the house is constituted for the first time. So that the governor's powers, of course, the governor has the power to call for a trust vote when there is no clear majority on the floor.
But not after the election that you have for the
It's
first
not after the election, because here the government is formed. Very valid point that, you know, this is post-formation of government. What is the power of the governor to call for a trust vote post-formation of the government? What are the circumstances in which he can,
That means a running government.
a running governor?
Correct. Well, let me answer on first principles. That of course, we can add some material and give your lordships specifically a note only on this. But well, on first principles, the first answer is that zero, where, because your lordship will decide abstract. Zero, answer to your lordship, direct question, direct answer. Zero power, where there are pending disqualification issues in a running government. Because the lordship should not mix up the two. One is a normal vanilla running government with no issue of disqualification. One is, fellows, a disqualification pending at two levels. My candid, clear answer to your lordship's direct question is zero. Number two, the reason is what I have given, fellows. It is a lateral entry of the executive in an area where there cannot be any jurisdiction. There is no locus, fellows, in either 10th schedule or your lordship jurisdiction.
Right.
Number three, if, fellows, your lordship's question is premised, has to be premised and rightly premised on the assumption that the governor, what he does in the question posed by the Honorable Chief Justice, what is he doing, Willis? He is recognizing ABC as the inverted commas majority. There is no relevance to your lordship's query unless the Willis governor does that. Otherwise, your lordship's query would not be Willis relevant. Obviously, it presupposes that he is giving some Willis imparting legitimacy, recognition, or some status. Well, how is that possible?
There's only one gray area.
In constitutional law, it's not possible.
Not so much from the facts of this case, but, you know, we're looking at now from the
Yes.
perspective. On the facts.
I'll tell Lordship.
When you read that letter of the 28th of June 2022, the governor, short while ago, you said that what the governor essentially did was to recognize a split by the letter. In fact, that letter does say that so many people have left you, and therefore, you know, that
Without using the word split, is a full recognition, my submission to the Lordship.
de facto recognition of a split.
Yes.
is there.
Yes.
Now, your answer to that is that the governor, so long as the disqualification petitions are pending, he cannot call for a trust vote for the simple reason that you are still a part then of the government which is supported when the House was formed.
Except in one case,
Right.
where, Willis, for some freak reason, which I cannot think of, it will never happen, that nobody decides to seek to disqualify the other. Now, Willis, suppose,
Often the speaker, what he may do is that to
no,
unless disqualify you at all,
no, but that is not so
then
simple.
you contribute to the majority of the.
No, but I am doing a juristic answer to your lordship's query. It can never arise in practice, but I am giving a juristic answer. That will have to be a situation where there is no cavil and dispute. I mean, it is virtually by consent of everybody. But with that answer comes a caveat. It goes back to the origin and the object of the 10th schedule. Why was it enacted? It was enacted not to encourage these trust vote situations by defections.
Just come now.
Unless that is so, it will rise every week, every 2 weeks.
One of the last point, maybe you can take 2 minutes to put this to the other side also.
Yes.
It's a worrying issue. There's no clear answer.
No, I'm very grateful because it helps us to clarify in our own minds also. Which is to clarify now.
There is, in assessing the strength of a ruling party in the House, whether it's the Legislative Assembly or the Parliament, you have a numerator and you have a denominator. The numerator represents the strength of the party when the house was formed. The denominator represents the total strength of the house. Now, by calling for a trust vote on 28th of June 2022, the governor, according to you, your argument is that the governor therefore recognizes that a part of the numerator has evaporated or has been taken away.
It's rather nice for putting a numerator. Yes.
The numerator has been taken away. And therefore now I feel you have lost the confidence in the house. According to you, that is not permissible because the disqualification petitions are still pending.
And he recognizes and gives legitimacy to the numerator. In your lordship example, he is recognizing and giving legitimacy to the numerator.
The only problem which I think, which is kind of not, which is worrying is, does the governor not also recognize that the very act by which the numerator may or may not be affected? All right. For instance, the numerator would be affected even if you don't treat it as a split, and there's a clear disqualification. Then the numerator is reduced by X, the strength of the ruling party in the house, minus Y, the people who have defected from, who have therefore attained disqualification. But equally, that same act affects the denominator also.
Because it reduces the total strength.
The total strength of the house.
Correct?
So, though the governor cannot therefore say, the governor cannot legitimately say that, look, these people have left you, therefore I want to trust.
Correct?
But can the governor not then say that, look, assuming that there is no recognizable concept of a split now under the 10th schedule, the effect of all this is that these people have to be reduced both from the numerator
I
and the
agree.
denominator.
Straight away. There are many answers. First, this exercise cannot be done by the governor because there is no mechanism for it generally.
You have been arguing that he can't assume to himself to take a decision.
First, I give your lordship 3 or 4 answers. Lordship will note down my very specific answer. This is an exercise itself which he cannot embark upon. The governor has no such jurisdiction to embark upon when there is a running house. Now, second answer.
Right. He can't embark. But can you not, therefore, then say, I want this exercise to be demonstrated on the floor?
No, therefore, no, I'm saying that exercise you can't embark. Let me answer.
Can you not?
Yeah, I'll answer.
He has argued that.
Second answer.
Argued that he won't have the. It has to be.
Whereas numerator, denominator, you can't start because your lordship has to premise a direction by me to him. I'm the governor, I'm giving him a direction.
In other words,
Please have
your
the.
argument.
You can't give a direction.
Got your point. Therefore, to
The legislature, the speaker or the chief minister can say, sorry, I don't obey this direction. I don't hear this.
Finish your argument, therefore, until the outcome of the disqualification petitions is known to the governor,
Exactly.
he cannot then call for a trust.
Two or three. Your lordship will take.
Possibly, using your line of argument, we're just trying to understand the argument and stretch it to its conclusion. After the disqualification petitions are decided by the speaker, then there is clarity in the mind of the governor on what is the extent of the numerator which has been affected.
I'm very grateful. I was going to answer, I'm not conceding, but I was going to answer because that question will arise. Your lordship will be very careful about a hypothetical situation, but possibly were. But because why is that? Because a constitutional designated judicial or quasi-judicial tribunal has given a verdict. After that, there is something, as the lordship puts it, that verdict, unless disturbed by the High Court or the Supreme Court, is binding or operative. But here, your lordship's query answers the first part. You are doing it well before.
There is another point in your favor, actually, which is that the very same unit which affects the numerator affects the denominator also.
Yes,
Right? So, if the governor cannot postulate until the disqualification petitions have ended that the numerator has been affected, then he cannot say that the denominator is affected.
No, he cannot. By the very arithmetic, it has to be both. It is very selective otherwise.
Right. Because the same act of defection which reduces the strength of the ruling party, which also then affects the strength of the house.
And Manas, can you start doing this in a this is the word premature stares your lordship in the face. Constitution says this body will decide. This body is ready to decide. You are going to give a decision virtually. I will reduce the denominator, I will reduce the numerator. That will create chaos. And Malas, your lordship has to see Malas
You are saying
also
he can't take cognizance of the existence of the 10th schedule proceedings. He can take only upon an order passed by.
Consequence of the 10th schedule proceedings.
After a determination by the 10th.
That's a very pithy summary. the consequence of the 10th schedule can be some basis, unless disturbed by the High Court or Supreme Court, to act.
Until then, they continue to be members of the.
And it would be in rem. Once that
Otherwise, this would be really a method.
there'll be chaos. There'll be chaos. And unless, not that it should come into your lordship cannot ignore the reality of around the country. Governors also.
We got your
Governors are no more angels.
Just 2 sentences. Number one, Manoj. 10th schedule doesn't recognize majority minority.
Absolutely. No question.
Correct?
Correct.
10th schedule postulates, Manoj, that even if there is a split of a majority, it can't be recognized. The governor knows that. The governor knows that, Manoj. And Manoj, 10th schedule, also, para 3 also said there must be a split in the original political party. 10th schedule, Manoj, para 3 said original political. Right.
What's your main
We know that there was no split. Governor knows there was no split in the original political party. So on what basis will he ever recognize? And your answer to your lordship's question, how will the governor call Manoj? Supposing one of the parties moves away from the coalition and goes to the governor along with the BJP and said, now we are.
That's not an individual act of defection.
Yes, that's right. So this is an individual act. It has to be the act of a party. Now you have recognized the majority as the party and writing a letter to the chief minister. This is unheard of.
So if a party says we don't support the government anymore, that's not a disqualification.
That's
We don't support. If the governor says you've lost one of your constituents, now.
Government falls.
That's fine. That's all right. So that, I'm sorry, but I didn't want to.
Very deeply obliged.
Thank you, Doctor.
Thank you, Doctor.
Yes.
Wait, please, for some lots, I'll be very brief, madam. Lots for 15-20 minutes. Lots, some issues have not been covered.
What are the points that you want?
Yes, madam, straight away. Lots, I have made a brief written note, but before I come to the note, madam, lots, I have made a chart of all the prayers for your lordships. And one or two areas which have not been addressed. If your lordships have that chart, madam, which has, my lord, the list of 4 writ petitions on this side and 2 writ petitions on that side. It is document 8. Madam.
Document A?
Yes, madam. It's a chart.
Document 8, Lords, consolidated prayers.
Filed yesterday, madam. It was- Serial number 1 and 2 are writ petitions filed by my learned friends. Lords, challenging the notice issued by the speaker.
First one.
Yes, ma'am. The first 2, but that was the, my lords, subject matter of 27th order. Now, my lords, item number 3 is a writ petition challenging the action of the governor, calling for the trust vote. Lord, that has also been addressed at length. That is item number 3. Now, my lords, serial number 5 at page 5 is a writ petition by us challenging a decision of the speaker on 3rd July 2022 after his election, changing the recognition of the whip from Sunil Prabhu to Mr. Gogavle. But this is a area which has not been addressed, which I will not briefly touch upon. Serial number 6, relates to the actions of the governor, lords, in administering oath to Shinde, and also, my lord, that whether your lordship should decide the disqualification petitions here. And lastly, my lord, serial number 7 challenges, my lord, notices of disqualification issued to us. Now, my lords, I will limit myself, my lord, to the challenge of 3rd of July 2022. And this challenge, my lord, is an independent challenge, irrespective of the view which your lordships will ultimately take as far as disqualification is concerned or governors, my lords, actions are concerned. Now, kindly have a look at the writ petition itself, my lord. The writ petition starts.
What is the writ petition number?
Yes, my lord. That writ petition is 479 of 2022. Yes. Starts at, my lord, 470 PDF, common compilation 1. 406. 406, no? No, it's not 460.
Common compilation.
Plus 6, my lord, I'm sorry, 406. Starts at
406. Common compilation.
Starts at 412. This period. Yes.
406.
406.
And if I can just quickly, my lord, point out my prayer there, which is, my lord.
One week.
I'm sorry.
Trying to pull out that. Which common compilation did you say?
Common compilation.
3C.
Common compilation 1,
Convenience compilation?
serial number 4. Convenience compilation
It is convenience compilation, not common
compilation. Right.
of documents.
Yes, yes.
Yes. Lords, kindly see my prayer.
Page?
Page, my lord, for PDF, page 408. 408. Lord, this is to quash and set aside the communication of 3rd of July 2022. And the grounds taken are not that the speaker could not have acted on the request of the legislature party. The speaker is obliged only to act on the directions of the political party as far as para 21B is concerned. The decision of the speaker itself.
Would not have acted on the,
Lord Lordship did not take down any notes, it's there in my note.
on the advice of the legislature.
Yes, that's right. I'll just show the documents, Lord, and straight away come to the note. If your lordships have the decision of the speaker, which is of 3rd of July, my lord, at PDF, my lord, 382
CC2.
of the same volume of CC, I'm sorry, my lord, CC2.
Which one?
My lord, CC2, page 382 of the convenience volume.
Serial number 5.
Compilation.
The running page is 369, PDF page 382. Your lordships are aware, my lord, this decision is taken after the election of the speaker, my lord, on 3rd, on the late night of 3rd. So kindly see what he says, my lord.
Just 1 second, I'm just trying to track it down. Convenience compilation 2, right? Yeah. Page
Page 382, I'm sorry.
382.
With reference to your above mentioned letter, I have been ordered to inform you that you have been replaced from the post of legislature party by nominating the name of Ajay Chaudhary. In this regard, you have raised the objection by addressing the letter on 22nd June. In this regard, after deliberation on provision in the law, Honorable Speaker, Maharashtra Legislative Assembly has cancelled the approval granted to Ajay Chaudhary as the leader, Shiv Sena Legislature Party, and kindly see the next, my lord, and approves the recognize the nomination of Eknath Shinde as the leader, Shiv Sena Legislature Party. Similarly, the proposal to nominate Sunil Prabhu as the chief of Shiv Sena Legislature Party is to be cancelled and to recognize the nomination of Bharat Gogavle as chief whip of Shiv Sena Legislature Party has been approved and recorded in the registry. So, my lord, my argument is limited to the second part of the decision.
Cancellation.
As far as, my lords, the replacement of Sunil Prabhu by, my lords, Bharat Gogavle by the action of the speaker on the 3rd. And the only material, my lord, which was there before the speaker was that letter of 22nd of June of, my lord, Mr. Shinde, which your lordships have seen, my lord. PDF, my lord, page 67.
It was seen.
Lordships have seen that, which encloses that resolution, my lord, of 21st, appointing, my lord, Sunil Prabhu.
Can you give us a cross reference?
Yes, my lord. That is page 60. No, the earlier one. The 67. The letter, my lord, of Mr. Shinde to the Honorable Deputy Speaker is at page 67. If your lordships just have a look at that.
Page 67 at the same compilation?
Yes, my lord. Kindly see, my lord, the heading. It is not by a political party. Shiv Sena Vidhi Mandal Paksh Karyalaya. Clear, my lord, that the letter was addressed by the Shiv Sena Legislature Party at best. And this, my lord, is based on the resolution which was passed in Guwahati. Which is, my lord, that resolution at page 49. 62. At, my lord's PDF page 62. Again, Shiv Sena Vidhimandal Paksh Karyalay. Sorry, sir. 55. PDF page 55. Again, the heading is also Shiv Sena. Yes, my lord. PDF page 55. Shiv Sena Vidhimandal Paksh Karyalay. Now, my lord, the defense to this, in the reply, there are only two defenses taken, which your lordship, my lord, have to consider. One is this is an issue which is covered by 212. Court should not get into it. And second, in any event, it is the legislature party which decides the whip. Straight away, my lord, if I can place the reply itself, there are only two issues, my lord, which have been raised in the reply. Kindly turn to, my lord's PDF page 475 of Convenience Volume 1, my lord. If your lordships have page 475,
Sorry, which convenience compilation, please?
Convenience Volume 1. Lords, I have put all this in the note. Your lordships may not be troubled, my lords, to make the
Why don't you take
note
us,
of the pages.
run through that note rather?
Yes, yes, Lord. I'll just point out the pages and
That
straight
will
away.
be,
Yes, sir.
while you read it, you can
I will.
indicate.
Yes, sir. Lords, if your lordships have page 475 PDF, their reply, my lords, to this writ petition. The second column, my lords, on the top, this is the answer to 479. Writ petition is not maintainable in view of 212. And in any event, speaker has no discretion in the matter and has to notify the will of the majority of the legislature party. The lordships have made a note, my lord. Similar, my lords, averments are made at PDF, my lords, 492, paragraph 35, 34, 35, and 36. So, my lord, these are the documents which I wanted to show. Now, straight away, my lords, if your lordships come to my note,
Your notice.
my lords, that is A2, my lords. A2, it's called additional WS.
Devdutt, your A1 is about the 7-judge issue, I think.
Yes, my lord, that's right.
Correct.
A2.
Lords, at PDF page 2, my lord, the first point, that as far as the validity of this decision is concerned, it's only your lordships, lords, who can take a view on this. And if your lordships kindly see paragraph 8 and 9, this issue on, my lord, whether the whip is to be issued by the political party or legislature party, lords, my senior colleagues have already made lords submissions. I will not repeat it. Paragraph 8, my lords, I've extracted 2B. And 9, my lords, I have given the reference to, my lord, Mr. Sibbal's submission, where not detail Erskine May, etc. Whether it's clear, my lord, that whip has to be issued by the political party and not by, my lords, the legislature party. Now, my lords, coming to the defenses raised in the writ petition, if your lordships have paragraph 12. Paragraph 12, my lords, I have extracted 212. If your lordship sees 212, I'm sorry. It's the paucity of time, my lords, I'm trying to hurry up.
Yes.
Lords, paragraph 12, 212 I have extracted. The first, my lords, criteria for 212 to kick in is that the validity of any proceedings in the legislature of a state shall not be called in question. So my submission is, my lord, that the decision of the speaker of 3rd of July 2022 is not a proceeding in the legislature of the state. And my lords, I am fortified, my lord, by Mohammad Siddiqui's case, which I have extracted in the next paragraph, paragraph 34, my lord. The above proposition makes it clear that the finality of the decision of the Speaker and the proceedings of the state legislature being important privilege of the state legislature, etc. The proceeding of the legislatures include everything said or done in the House in the transaction of parliamentary business. Now, my lords, deciding a whip or giving recognition to a whip has nothing to do, my lords, with parliamentary business. Therefore, the primary, my lords, ingredient of 212 is not satisfied. Second, my lord, is a more fundamental argument that this is not a mere, my lords, case of procedural irregularity, but a case of substantive illegality and unconstitutionality. Your lordships, my lord, have from time and again said that 212 will not, my lords, help the Speaker's decision to be immune from judicial review if it suffers from substantive illegality or unconstitutionality, even if it is proceedings in the House. Lord, the latest judgment here extracts the Constitution Bench judgment in Raja Rampal. And if I can just place, my lord, paragraph 431 of Raja Rampal, which is extracted at page, my lord, 6, PDF 6. Conclusion, my lord, S, bottom of that page. The proceedings which may be tainted on account of substantive or gross illegality or unconstitutionality are not protected from judicial scrutiny. Then similarly, my lord, an ouster clause attaching finality to a determination does not oust the power of judicial review, but not on grounds of lack of jurisdiction or it being nullity for some such reason as gross illegality, irrationality, violation of constitutional mandates. Yes.
Yes.
Now, my lords, as far as, my lord, the decision is concerned, that this is not a procedural irregularity, but a substantive illegality or unconstitutionality is borne by a plain reading, my lords, of paragraph 2 of the 10th schedule. And, my lords, all the authorities and material which has already been relied upon, that references I have given. If your lordships have paragraph 9, my lord, I've given the references, page 70 to 96. Paragraph 9, page 4 of this note, and I will not, my lords, repeat it. Now, my lord, the second point. Third heading in my note. What is the meaning, my lords, of a political party? Your lordships asked, my lord, during the course of our submissions. What does it mean? Now, my lords, I have tried to explain, because ultimately decisions of a political party, which I will demonstrate, my lord, are ultimately decisions of the political party expressed through its leadership. And when, my lords, 2B talks about directions of the political party, it means decisions of the political party as are communicated, my lords, to the Speaker. Now, my lords, kindly have paragraph 19 of my note. The 10th schedule of the Constitution prescribes a code of prohibited conduct for legislatures within and outside the House. Any commission of the prohibited conduct by a legislature envisages penalty of disqualification. Now, my lord, there are two categories of prohibited conduct which your lordships have seen, my lord. And the footnote will show, my lord, I'm not going to repeat it, what is prohibited conduct for the purpose of para 21A. I've given the references also. Resignation need not be, Lords, explicit, it can be inferred, giving a letter to the governor, Lords, going to the governor with the opposition parties constitute para 2(1)(a). All the references are there. Now, my lords, the substantive submission on the term political party, if your lordships have paragraph 21 now.
It's not a nebulous concept.
The term political party occurring in the 10th schedule is not a nebulous concept, but a term which has a definite connotation. The term political party referred to in the 10th schedule is an association stroke body of persons which has a definite leadership structure which is recognized by the Election Commission of India under section 29A of the RP Act. A political party is not synonymous with its legislators. A political party includes in its ambit the entire organizational structure which is spread at several levels, block level, taluka, district and state level, apart from the primary members holding those posts. Your lordships have seen, my lord, as far as Shiv Sena was concerned, organizational elections were held in 2018 and the leadership structure was communicated in January of 2018. The documents your lordships have seen, I'm not going to point it out again. But those documents unequivocally show, my lord, who's the leadership of the political party. That is page 1, my lord, of convenience compilation 2. Now, my lords, there is how this concept, my lord, of political party was included. What is the history? I will not trouble your lordships with that. If your lordships straight away have now 29A, which is extracted in para 28. Now. Why this is important is that political party, my lord, is not something which is anomalous. It is very clear who are the members, what is the leadership structure. So when the 10th schedule says directions of the political party, it means the directions of the political party as is expressed through the political leadership of that party. Paragraph 28, my lord, 29A is extracted. If your lordships have PDF page 12, subsection 4 of 29A clearly states that the application shall contain the details of the president, secretary, treasurer, and other office bearers. So the leadership structure what has to be intimated to the election commission. Now, my lords, detailed guidelines have been made under Article 324 under section 29A. And that also, my lord, is a part of this very written submission. If your lordships, my lord, just have PDF page 21, it requires, my lord, the following documents to be submitted, which includes office bearers. Your lordships may kindly make a note at page 22, and also, my lord, affidavits to be given by the president and secretary, which is, my lord, PDF page 34. So therefore, my lord, coming back to my note, my lord, paragraph 30. The fact that Shri Uddhav Thackeray is the president of the party, as per the constitution of the party, was intimated to the Election Commission from time to time. Thus, the terminus quo for deciding a disqualification petition under the 10th schedule in regard to the prohibited conduct of a legislature has to be with reference to the state of affairs of that political party as it existed on the date of alleged action of disqualification. The term political party in the 10th schedule is referable to the political party as registered and recognized by the ECI under section 29A. Now, my lords, the next section that the 10th schedule is intended to maintain the integrity of the political party, my lord, your lordships have been taken through it. I will not, my lords, trouble your lordships with that. If your lordships now have serial number 5, Roman 5, my lord. Lord, this submission here is. No, Roman 5 at page 15. The correct constitutional conduct for legislators who claim that they represent the original political party is to first get their claim resolved before indulging into prohibited conduct under the 10th schedule. Now, my lords, the core question, my lord, which arises for consideration of your lordships in this case is that when there is an intra-party dispute, can, my lord, certain MLAs take the defense that, look here, I am the political party and I will indulge into prohibited conduct under the 10th schedule. And after indulging into prohibited conduct, toppling government, forming the government, file proceedings on 19th of July before the Election Commission for, my lords, validating that claim. And the defense taken is, look here, I am the political party. So your lordships, my lord, are called upon to decide what is the correct course of conduct in this situation. Para 36, my lord, it is respectfully submitted that in the event of a dispute within the political party, the correct constitutional conduct for legislators who claim that they represent the original political party is to first get their claim resolved before indulging into prohibited conduct under the 10th schedule. It is submitted that if a legislature or a group of legislators have a claim that they represent the original political party, then it is imperative that such a claim has to be resolved or adjudicated upon and decided in accordance with law. Brahmanand Reddy, my lords, was already cited. It is no defense in a disqualification petition to say that the defectors have a claim of constituting the original political party. Till such claims of MLAs that they represent the original political party attain fruition by a process known to law, such MLAs are governed by the code of conduct prescribed by the 10th schedule. Any other interpretation would make the working of the 10th schedule untenable. In the facts of the present case, Sri Eknath Shinde and his faction resorted to prohibited conduct of violating the whip, indulging into anti-party activities, instead of getting their claims adjudicated or resolved in the first instance, and then indulging into political activity. So now the question is whether you undertake political activity contrary to the 10th schedule, indulge into prohibited conduct, or first get your claim resolved. Any other interpretation would lead to 10th schedule being rendered unworkable. This can be demonstrated by a simple example. A legislative assembly has 40 members. Political party A, headed by Mr. X, has 5 MLAs. Party A forms a coalition government with Mr. X as the chief minister. Subsequently, 3 MLAs out of 5 claim that they are the real political party. The said 3 MLAs go to the governor along with the opposition parties to form the government. If the disqualification petitions are filed against those 3 MLAs, the petitions will have to be decided with reference to the state of affairs as it existed on the date of prohibited conduct. This is in line with Rana of relating back. Thus, the faction of 3 MLAs should first get their claim of being the real political party adjudicated and determined, and then take a political decision instead of putting the cart before the horse. This is the only interpretation which harmonizes the provisions of the 10th schedule and the symbols order. This interpretation will harmonize various competing interests and objects and ensure that the integrity of the political party is maintained, and at the same time giving individual MLAs or a group or a faction the opportunity to get the political leadership changed in a manner known to law. My lords, the next submission, my lord, that if the contention of my learned friends is accepted, that moment there is a dispute within a political party, there can't be a disqualification petition, will lead to a complete constitutional hiatus, my lord, as far as 10th schedule is concerned. That, my lord, in paragraph 40, it is respectfully submitted that there cannot be any hiatus in the working of the constitution. It is the contention of the respondent. If the contention of the respondent is accepted, that the 10th schedule proceedings are hinged on a future declaration of their status and or their claim of being the political party, then it would result in a situation where in every case of disqualification, a defense would be taken that the defectors represent the political party and therefore no action of disqualification can be taken. Taking the argument to its logical conclusion, it would only mean that till such claim of the defection defecting faction that they represent the political party is decided by a competent forum, the 10th scheduled proceedings cannot be proceeded with. This would result in a constitutional hiatus. Lord, then I have cited Supreme Court of Canada, my lord, that on constitutional interpretation, and also, my lord, your lordship's judgment in the Advocates on Record Association. Then, my lords, serial number 7. Lords, I respectfully submit that ultimately, my lord, your lordships will have to lay down the batting order, as my lord Justice Narasimha put it. Lords, that is paragraph serial number 7. It is imperative for this honorable court to lay down a constitutional sequence in order to harmonize the 10th schedule 179C as well as para 15. As is evident from the facts of the present case, the respondent MLAs, instead of first resolving their claim in a manner known to law, have resorted to prohibited conduct. The proceedings before the Election Commission were initiated only on 19 July, that is much after the disqualification petitions were filed on 23rd June 2022. Then paragraph 44 is the Lord's submission. Thus, it is imperative that this honorable court lays down this constitutional sequence and the legal permissibility of 3 distinct constitutional stroke statutory procedures, namely 1, proceeding of disqualification under the 10th schedule, that is 1. Second is 179C, my lord, which has already been argued, and then, my lords, paragraph 15 of the symbols order. It is respectful submission of the petitioners that the 10th schedule proceedings necessarily have a constitutional precedence over 2 and 3 above. Second, my lords, para 15 proceedings, which are based on the majority test, cannot be undertaken and proceeded with without final adjudication of the 10th schedule. And third is the nabam rebia, my lord's argument. Then last 2 submissions, my lord, are on the symbols order. And my lords, I have submitted that the reason is, my lord, that decision to the defense.
That's not an issue which falls here.
Yes, my lord. One of the questions which was referred to your lordships, my lord, in the reference order relates to the power of the Election Commission. But the only defense which is taken, my lord,
Separate.
yes, my lord. The reason is, my lord, the defense which is going to come, the lordships will probably hear, is that look here, we have now been adjudicated as the party. So therefore, the disqualification petition are anyway not maintainable because it is, my lords, given by a person who is not the political party. So, my lord, just 2 submissions on that. If your lordships have paragraph 47, my lord, I have submitted that as far as para 15 is concerned, it cannot be undertaken, my lord, without determination of the 10th schedule, which your lordships will examine in other matter. And last, my lords, paragraph 49 and 50 is that the decision of the Election Commission, my lord, is a declaration of status, that who is the political party pursuant to a split which has arisen. That can only have a prospective, my lord's, effect. It can't relate back. Kindly have, my lord's, paragraph 49. It is submitted that under paragraph 15 of the symbols order. Yes. It is submitted that a decision under paragraph 15 of the symbols order is a decision which can only have a prospective effect. Then, my lords, I have quoted paragraph 15 of the symbols order. It's a quasi-judicial, my lords, adjudication under the symbols order. That, my lord, adjudication of the dispute results in an order declaring, my lord, XYZ as representing the political party. And this submission is, my lord, that can only have a prospective effect. Now, my lords, kindly see the consequence. If it is held otherwise, that it relates back, it would have, my lord, in our respectful submission, complete, my lord, disastrous consequences as far as the 10th schedule is concerned. Because when the decision comes, for instance, in this case, it has come in February, my lord. Petition moved in on 19th of July. And today to say that in view of this decision now, in February 2023, all the actions of prohibited conduct get effaced, my lord. would be to destroy the complete intent, letter and spirit, my lord, of the 10th schedule. Lords, all the other submissions and judgments are there.
Thank you, Mr.
I'm grateful for a very patient waiting. Grateful.
We'll start after lunch, but just before we rise, Mr. Paul will first argue, thereafter Mr. Jetulani and then Mr. Manandan. Roughly, Mr. Paul, how will you space out your submissions? How long would you take? You'll take the rest of the day today?
My lords, the Solicitor General would, of course, also appear.
I am allowed the governor.
So,
My
Mr.
lords,
Paul,
I would definitely take today,
right.
whatever time, and tomorrow, my lords.
Day and tomorrow is Wednesday.
Yes, my lords.
Entire.
Yes, my lords, I have 3.5 days of arguments, or 4 days of
All
arguments.
right. So we want to wrap up the matter by the end of this week.
Right.
So, what we would suggest is that, you can begin, of course, you will take the whole of the day today. If you can sort of complete, say, 1 hour after lunch tomorrow, say by 3 o'clock, that would ensure that then Mr. Jetlani and Mr. Maninder Singh can conclude, say, by tomorrow evening. And then the solicitor can get a little time day after, and then the rejoinder.
So I'll try my best.
Okay. Mr. All right, let's do it this way. Mr. Sibal, between you and Mr. Dr. Singhvi, how long would you anticipate for a rejoinder? I mean, that
Well, if it's 2 o'clock in the afternoon on Thursday, we'll finish by 4.
So if you
Between
can.
us, we finish by 2
On Thursday, I may not take more than 1 hour, 1.5 hour, my lord, maximum.
All right.
We'll endeavor to finish by 2 o'clock on Thursday.
That's right, that's fine.
So then, what we were suggesting was, if you can, between the three of you, you can finish by tomorrow, ideally. Then, the solicitor says he'll take about 1 hour or 1.5 hours on Thursday. So if he begins at 11, by 12:30, he'd be done.
Then
So we still have a little bit of a half an hour margin. He said 1.5 hours. So, we just.
Try our best, my lords, is all I can say.
Between the three of you and the solicitor, if you can finish complete by Thursday, 2 p.m., then they have the rejoinder after lunch on Thursday.
That's enough for us.
Then, so maybe the three of you and just Mr. Solicitor can also have a word, so that, you space your arguments and, what you're going to argue, so that
Your
is the
lordship,
time.
your lordship is sitting at 3:15 for a bail matter, we're told. So
350.
we'll only be sitting in the bench till
350.
3:50.
We thought because 3:15, then we'll really eat into your time.
Yes.
We might continue beyond 4 o'clock, but we'll.
Obliged.
Very good.
Right.
Right, your lordship.
check, check, 1, 2, 3, check. Check, check, check.
स्वीकार नहीं कर सकते। अगर सीमा की सुरक्षा पर आपको नौजवान को भेजना है, जिसे वर्दी पहन करके सम्मान की बात हो, उसे परमानेंट नौकरी चाहिए, पुरानी नौकरी व्यवस्था होनी चाहिए। ये अग्निवीर जैसी व्यवस्था के पक्ष में हम लोग नहीं हैं। सरकार जहां सपने दिखा रही है $1 ट्रिलियन इकोनॉमी का, बड़ी बड़ी इंडस्ट्री के लोगों का स्वागत कर रही है अध्यक्ष महोदय, वही एमएसएमईज का क्या दोष है जो सबसे ज्यादा नौकरी दे रहा है, सबसे ज्यादा रोजगार दे रहा है। इन्वेस्टमेंट मीट में आए, बड़ी खातिरदारी हुई, कूपन को लेकर के कूपन बांटे गए। जब इन्वेस्टर्स लंच के लिए कम पड़ गए तो कूपन फ्री बटे, जिसको टाई पहन करके, अच्छे कपड़े पहन करके और कूपन हासिल करके लंच कर ले। ये स्थिति थी। जो एमएसएमई है उसके लिए क्या किया? ये बड़े उद्योगपति तो पहले भी आए थे, आखिरकार जो एमएसएमईज के लिए होना चाहिए था, सरकार ने क्या किया? और सरकार बता रही है कि न जाने कितनी कारखाने लग गए हैं, कितना फाइनेंस हो गया है, न उनको बैंक फाइनेंस दे रही है। और सरकार बताए कि अगर एमएसएमई बहुत लगी है इनकी सरकार में, तो आखिरकार बिजली का कनेक्शन कितना लिया है उन्होंने? केवल डेटा पे बता देना कि इन्होंने एमओयू कर लिया, ये सच्चाई से दूर होगा जब तक बिजली का कनेक्शन नहीं बताया जाएगा। एग्रीकल्चर सेक्टर के बिना आप इकोनॉमिक ग्रोथ कैसे पाएंगे? एग्रीकल्चर सेक्टर का क्या हाल है? हमारी नेशनल से भी नीचे बिलो जा रही है एग्रीकल्चर। और कम से कम जो फसलें पैदा हों उनकी एमएसपी तो सरकार दे। क्या सरकार ने एमएसपी दी है? और अभी जितने भी हमारे माननीय सदस्य होंगे वो जानते होंगे, आलू की फसल चौपट हो गई है। किसान को जो कीमत मिलनी चाहिए वो नहीं मिल पा रही है। वो बजट में कहा गया कि उनके लिए, इनके घोषणा पत्र में कहा गया कि 1000 करोड़ रुपए से रखे जा रहे हैं कुछ फसलों खरीदने के लिए। मैं अध्यक्ष महोदय आपके माध्यम से जानना चाहता हूं, जो पोटैटो बेल्ट है, आज तक सरकार ने कितनी खरीद की है आलू की? ये सरकार कम से कम आंकड़े हम लोगों के पास रख दे। ओडीओपी बहुत फेमस, सरकार ने पूरा का पूरा प्रचार ओडीओपी, 1 डिस्ट्रिक्ट 1 प्रोडक्ट, एक लंबी सूची है 1 डिस्ट्रिक्ट 1 प्रोडक्ट की। हर डिस्ट्रिक्ट का सरकार ने आइडेंटिफाई किया है कि वहां पर कितना बजट दिया जाएगा, कितना ओडीओपी में काम हुआ होगा। अध्यक्ष महोदय, यहां पर जितने भी सदस्य हैं, पूरे प्रदेश के बैठे हुए सदस्य हैं, आगरा में लेदर प्रोडक्ट के लिए क्या बजट था? अलीगढ़ के ताले और हार्डवेयर के लिए कितना बजट दिया गया? अंबेडकर नगर हमारे बुनकरों का भरा पड़ा है। बुनकर जो सुविधाएं समाजवादी सरकार में मिलती थी वो सभी सुविधाएं छीन ली गई। और 1 डिस्ट्रिक्ट 1 प्रोडक्ट में कहा गया कि टेक्सटाइल प्रोडक्ट्स को हम बढ़ावा देंगे। सरकार बताई कि टेक्सटाइल प्रोडक्ट के लिए क्या बजट दिया है। औरैया में फूड प्रोसेसिंग, और फूड प्रोसेसिंग में देसी घी, हमारे माननीय सदस्य बैठे होंगे, बताओ देसी घी के लिए बजट क्या दिया गया? अयोध्या में जैगरी, क्या बजट दिया आपने जैगरी के लिए? बलरामपुर फूड प्रोसेसिंग, कितना बजट दिया गया फूड प्रोसेसिंग के लिए? भदोई कारपेट दरी, वही इंफ्रास्ट्रक्चर जो समाजवादी सरकार में बना था, उसके अलावा सरकार ने क्या दिया वहां पर? फिरोजाबाद में ग्लासवेयर के लिए बजट क्या था? हमीरपुर के लिए शूज के लिए बजट क्या था? बांदा के लिए बजट क्या था? झांसी का सॉफ्ट टॉयज बजट क्या दिया आपने? कन्नौज में परफ्यूम, इत्र, अतर, पता नहीं खुशबू से क्या नफरत है सरकार को। बहुत नफरत है खुशबू से इनको। अध्यक्ष महोदय, माननीय सदस्य ने कहा कि छापा पड़ गया, मुझे अच्छा लगा कि पूछ लिया। अध्यक्ष महोदय, जिस पे छापा पड़ा था वो भारतीय जनता पार्टी का था। अरे अध्यक्ष महोदय, मैं माननीय सदस्य से कहूंगा अध्यक्ष जी से मिल ले चुपचाप, क्योंकि कानपुर के जिस उद्योगपति पे छापा मारा गया था उससे समाजवादियों का कोई रिश्ता नहीं था, क्योंकि चुनाव उत्तर प्रदेश में था। समाजवादी लोग कैसे बदनाम हों, समाजवादियों पे कैसे आरोप लगे, इसलिए वो छापा मारा गया। और गलती डिजिटल इंडिया की थी, क्योंकि जिसने इत्र का और परफ्यूम का लॉन्च किया था
Check. Control room, testing, testing. Check, mic check, sound check. Yes, coming. Check, 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 sound check. Audio check. Check, check. into my document, like checks 1, 2, 3, 4. I can do it. But
check. check, 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 check,
Okay, please. But I address your lordship on each of the questions referred, your lordship, because my respectful submission is going to be that a large number of the arguments have gone far beyond the questions referred. My lords, as I was respectfully submitting, according to us, a large number of arguments are far beyond the questions referred and really are not relevant to the issues at hand. Be that as it may. What is the basic premise of the case of the petitioners over the last 3.5 days? That because there was a split in the legislature party, we, the respondents, stand per se disqualified. And because we stand per se disqualified, ex facie disqualified under para 21A and 21B of the 10th schedule, the Supreme Court of India should bypass all coordinate constitutional authorities and decide itself whether we are disqualified or not, or in fact, effectively saying we are disqualified. Hold that. Secondly, till that disqualification is decided, neither should the floor test have happened, nor should the governor have taken a decision, nor could the ECI have taken a decision, because if ultimately they are held to be disqualified, it will have a bearing on the decision made by any of these authorities. And thirdly, because it is your lordship's order of 27th of June, 2022, which led to the toppling of a government, only your lordships can correct that wrong and restore status quo ante. Now, my lords, this fundamental premise on which the entire edifice of this case is based suffers from some basic problems before I come to the issues in hand. Your lordships have time and again held that we will not act as the court of first instance, especially where coordinate constitutional authorities have been specifically vested under the Constitution with the requisite powers to decide an issue. There is also a presumption that we are per se disqualified, so you're the jury, you're the judge, you decided yourself without any constitutional authority till date. having given any finding on our disqualification. You've decided, you've presumed it so. But more importantly, my lords, and before I get into the issues, I want to touch the issue of governor. It is of some concern. There were emphatic assertions made that when my Lord the Chief Justice and your Lordships put a question, that what should the governor do in a case where not before the government is formed, but after the government is formed, there is a problem, should the floor test be ordered or not? What is the course of action that the governor should adopt? And the answer given was that floor test ought not to take place. Only a no confidence motion could be moved in such a situation. And Dr. Singhvi said that where disqualification petition is pending, my answer is 0 as far as holding of a floor test is concerned. With utmost respect, these submissions of the petitioners are in the teeth of 9 judges of this honorable court in Bomai, are in the teeth. We are told that the concern in this matter is not about who wins and who loses, but maintaining constitutional propriety and institutions. And I think the arguments sought to be now forwarded before your lordships are destructive of the entire constitutional scheme as settled by your lordships in a catena of decisions, including the 9 judges in Bomai. Also reiterated in Shivraj Singh Chauhan's case, where your lordships relying on Bomai said that it is incorrect to say that the floor test can only be directed to be ordered by the governor before a ministry formation and not after. In fact, your lordships' words used in Bomai and Shivraj were, it is the duty of the governor to hold a floor test. The only constitutionally ordained forum is the Assembly of Parliament, and no governor or individual in his own opinion can form a view whether a majority has been won or lost, and the only way forward is a floor test. And the court frowned upon the tendency because there used to be a huge misuse of Article 356 to dismiss governments and dissolve houses. So there was, the courts frowned upon it and said that the first instance, the governor must call for the floor test in such matters. Now, my lords, what happens in this case? In this case on the 27th, and in my earlier submission before your lordships on Navam Revia, I had even then said that I'm not for a minute suggesting that when we filed our 32, Navam was not one of our cases. That's not our contention at all. Navam was one of our important arguments. The other was equally important, was violation of principles of natural justice. And the third was imminent, immediate danger to the lives of the MLAs whose houses were being burned and relatives being threatened. That is why we came in a 32. And that is hugely different and was not barred by Quixote at all. Because our contention was not that your lordship decides on the disqualification petitions, as they are claiming. That was not the prayer in our petition. Our contention was that Navam, even as it stands today, has held the judicial field. It is a constitution bench decision, and the speaker had no jurisdiction to proceed with the matter at all, apart from the principles of natural justice being violated. The court, keeping all this in mind, only on the issue of natural justice on that day, extended the time, did not injunct the speaker, extended the time. Now, extension is interpreted to say because extension was granted till 12th of July, it effectively meant an injunction. I don't see how. If you violate a provision of the rules which says adequate notice should be given, the speaker doesn't give that notice, the Honorable Court says gives them more time. Now, after that, my lords, what does the governor do? The governor in his letter writes to say that 7 independent MLAs who were supporting a ministry have withdrawn support. The leader of the opposition has written to me to say that they have no confidence in the ministry. Within the ministry, a large section of the legislative party have moved a resolution saying that they do not support the MVA ministry and government. Given these facts, I think it prudent and call upon the then Chief Minister, Mr. Thackeray, to come and prove his majority on the floor of the House. Lords, I put a question to myself, what else is the Speaker, the Governor expected to do? Your Lordship's words again in Gumai are, by whatever process or means. The words used by your Lordships in Gumai are, by whatever process or means, the Governor can gather the information that is required, which raises a credible doubt as to the majority of a government in power. The only course open is a floor test. And that is what the Governor goes ahead. You refuse to face that floor test. And your only answer to that is, it was a fait accompli. So, my lords, if democracies which have to be tested on the floor of the House are going to be decided on, it's my fait accompli, so I won't go and face a floor test, and yet want to continue in government, is that acceptable? Is that constitutionally acceptable? The only mechanism known is a floor test, and you evade that. And then you cast aspersions on a constitutional authority to say, which in any case today is the norm, you can cast any aspersion on anyone you want to. And you say that the Governor in question failed to discharge his duties, acted with bias in a malafide manner. Because what was he expected to do? 7 independent MLAs say we have lost confidence. The leader of the opposition writes, 34 of the 55 MLAs pass a resolution saying we have no faith in the ministry any longer. Now, before I proceed further, my lords, before I proceed issue-wise, I want to show these two judgments. Because so much time has been spent on the powers of the Governor and that he acted with malafide intent, and the solutions that your Lordship asked for, what could have been done by the Governor, it is said he definitely could not have asked for a floor test. And the only way to get out of all these judgments is to say that those cases did not involve a disqualification petition pending. Now, my lords, the moment your Lordships in Shivraj Singh Chauhan, Kuldeep Bishnoi, and any number of judgments have said that, and Shivraj Singh Chauhan especially, that proceedings under the 10th schedule, which concern disqualification and a trust vote, operate in entirely different fields. In the meantime, the right of an MLA to participate in the proceedings of the House continues, and he continues to participate and vote. Now, my lords, if their submission is taken to be correct, firstly, it's wrong because it's in the teeth of what Gumai and Shivraj Singh Chauhan says. Then when your Lordship asks them what could be done, they say 0 definitely if disqualification petitions are pending, which is in the teeth again of Shivraj Singh Chauhan, which says that irrespective of disqualification pending, irrespective of resignation letters pending, they will participate in the House. And that comes back to the same question that if an MLA is permitted to participate in the floor of the House, the legality as far as those proceedings are concerned can't be questioned. You can't say that all proceedings, budgets, decisions, bills passed will all be annulled and we will restore status quo ante. And when I come to Rana, I'll point out to my lords, Rana is completely misread. Rana was in the context where the Speaker's power, the Supreme Court held that when the Speaker decides a disqualification issue, he sees the events as on that date. Because there, a set of MLAs had gone and shown support to a rival faction and gone to the Governor. The split took place later. They sought to seek the defense of the 10th schedule as it then existed. The Supreme Court ultimately said no. As far as the Governor is concerned, the facts will be seen on the day. When they approached the Governor, the Supreme Court never said that the MLAs who participated in trust votes, the MLAs who've taken decisions, proceedings which have been legally conducted, will all stand annulled. Because ultimately it comes down to the argument being that if ultimately your lordships were to hold them to be disqualified, the EC proceedings couldn't have gone on, the trust vote could not have happened, and thus restoration of status quo ante, which would mean annulling everything that has happened. That's effectively the argument being made before your lordships. To stay the EC proceedings, 4 hours of arguments were addressed that EC should not go on with the same argument. That if EC goes ahead with it and later on it's found that these people are disqualified, they have no right to approach the EC. And a question was put by our lordships even on that day, what about his right as a member of a political party? In any case, who will decide this? Whether there has been a split in the political party, and then you presume, as if I have argued that there is only a split in the legislature party and not in the political party. We have consistently said so, including in our resolution dated 21st of June 2022, that a legislature party is integral and organically connected and co-joined to a political party. What is said in the legislature party is a reflection of what is happening amongst millions and thousands of cadres of the Shiv Sena across the country, because there was a huge discontent of aligning in the MVA with people who you were ideologically opposed to right through your political careers and existence. That was where the discontent arose from. That you fought an election with another party, after that suddenly we went along with another party. That was the political discontent. So we were conscious and rightly talked about the political party discontent. But who will determine this? Who is the whip? There are two whips we are talking about. They say your whip is only appointed by the legislature party. We say no. To say that our whip appointed by the legislature party does not represent the authority of the political party is wrong. Ultimately, right or wrong, the EC today has taken a decision. That's the subject matter of another petition which your lordships will decide. But even on that day when a stay was asked for, our respectful submission was, how can the Supreme Court today, without the concerned constitutional authority at all deciding on the issue, take a call on these matters? Just because you say so and you presume we are per se disqualified. Now please have, my lords, Bomai and Shivraj Singh Chauhan only on the powers of the governor before I proceed, because that's one of the most glaring submissions made in the teeth of settled law of the land. Please, for the judgment.
So your submission starts with the primary principle that proceedings under the 10th schedule operate independent of the power of the governor. Irrespective of the pendency of the 10th schedule proceedings, at any point of time, the governor can ask a floor test.
And
number one. And if he asks, then are there any limitations with respect to the fact that the 10th schedule proceedings are pending? Should he wait, not wait? Because the primary question will depend upon.
Yes, I bow down. My lords, I bow down. Your lordships have summed it up very well. May I just add to what your lordships are saying? In addition to what your lordships summarized, is my second limb of the argument that your lordships have already held in any number of judgments that an MLA during pendency of a disqualification petition is fully entitled to participate and vote. If that were so, then what is the hindrance to a floor test being conducted? And in all those matters, the issue arose the same. During pendency of disqualification petition, should the floor test take place or not? I'll show those paras. And your lordships answered by saying, why should the floor test not take place? In the meantime, you can't, without the decision of the speaker, say that a person is disqualified. So
there's a little catch there.
You see,
there's a catch there.
The problem really is this, that the antecedent circumstances which give rise to the necessity of a floor test are based on an alleged defection.
Right.
So, why is the floor test necessary? The need for a floor test arises because of the fact that a group of legislators may be disqualified as a result of their having formed a split from the party. This may or may
not from, but
yes.
Within there's a rival
the legislature party. Now, if the validity or the legitimacy of the split is itself in question, then holding or directing the holding of a floor test before the disqualification issue is resolved would result in this, that are you not then putting a premium on the very circumstances which gave rise to the disqualification?
So my lords, your lordships have answered that. And I'll show those judgments where this very question arose. That can those MLAs against whom a disqualification petition is pending participate in a floor test.
There also you are right.
Look at the reverse.
Because the law is very well settled that the mere pendency of a disqualification petition does not preclude a member of parliament or the legislature in the state from exercising all rights and performing all functions of a legislator. Undoubtedly. But equally, we have to be cognizant of a situation where the reason why he or she can exercise all the functions as a legislator is because the speaker has been not permitted to decide the disqualification issue.
May I, with respect, say, my lords, as far as that
So
is
step
concerned,
one, the speaker is told to defer a decision on the disqualification issue. So the disqualification issue cannot be decided. Therefore, why can the legislature not be restrained from exercising all rights on the floor of the House? Because of the judicial edict that you shall not hear the disqualification until the 12th of July, step one. Step two, why is the trust vote required to be held? Up to the 21st June, there was never any requirement of a trust vote. What is the requirement of a trust vote? The requirement of a trust vote arises because these 7 independent MLAs, then the 34, they all start clamoring and they say, well, there is disquiet within. We don't owe allegiance, and our chief minister has lost the confidence of the party. Now, the point of the matter is this, that if that is the reason for the unsettling of the government in the House, then the antecedent basis of that is itself the allegation of disqualification. So if you allow a government to be toppled then in circumstances
may I, with respect,
like
say,
this,
firstly, and
Yes.
I said I've just begun.
This
There
is
no
okay.
timelines and-
Just flagging it.
Yes,
Just
yes.
flagging it.
yeah, we are just flagging it.
No, I am very grateful. I'm very grateful. Yes.
Right? These are the concerns.
Yes, yes.
This is not a case where, say, there is a 3-party or 4-party coalition in a state. 2 parties say we are pulling the rug. They're entitled to, there's no disqualification. You have 4 parties which have come together in an agadi, and those 2 parties say we are pulling the rug and we want to get out of this government. It doesn't have the mandate of why we came together. Governor can simply say, the 2 of your constituents have, pulled out. Now, please show me that you established, you have the allegiance of the House. Because there is no, the problem arises in cases like this, where the reason for the trust vote is so intrinsically related to the alleged disqualification itself. You're right. My judgment in Shivraj says that, well, these are 2 independent issues. But there is
No, let me.
also an intrinsic
So, my lords, let me.
Call one another thing. In addition to this, what are their submissions? There is no difficulty that both are independent. Correct? There is no difficulty that both can go together simultaneously. But their submission is correct that if those persons who are to be against whom the disqualification proceedings are pending are permitted to cast their votes on the floor test in the no confidence motion. If ultimately after some time, correct, the speaker takes a decision and they are disqualified from day one, from the date of their conduct, correct, then what will happen to that? So their case is that it is better, correct, that the disqualification proceedings are initiated first. That is what their submission. You have to answer that also.
Yes, my lords, I will.
That is the crux of that main submissions.
May I? Let's firstly.
You can argue on this was only warm up.
Yes,
let's start with Bomai.
Yes, I thought let me start with that and I'll come. I'm conscious what my lord has said. I'm very grateful. I'll address those questions.
Anything more than 5 in that sense is gospel for us, because we are bound by.
Absolutely.
Not only that, my lords, of course, your lordships are right there, but even I want to show 2 paras, even as far as Bomai is concerned, on how Shivraj deals with it. It's important for your lordships to see that.
Fair enough. So we'll see Bomai and then.
Yes, first please see Bomai and then see.
Overarching principle.
Yes, yes. Judgment. Judgment, volume 2. Kindly have para 119.
Where is it? Conveyance compilation?
Volume 2, my lords.
Okay.
Judgment compilation, volume 2, PDF page 368. PDF page, as well.
PDF page?
PDF page 368.
358.
368.
This is quite dismissal.
No need.
119.
Savant.
360. Who gets read?
My lords, may I?
Yes.
Absolutely. But in this connection, it is necessary to stress that in all cases where the support of the ministry is claimed to have been withdrawn by some legislators, the proper course for testing the strength of the ministry is holding the test on the floor of the House. That alone is the constitutionally ordained forum for seeking openly and objectively the claims and counterclaims in that behalf. The assessment of the strength of the ministry is not a matter of private opinion of any individual, be he the governor or the president. It is capable of being demonstrated and ascertained publicly in the House. Hence, when such demonstration is possible, it is not open to bypass it and instead depend on the subjective satisfaction of the governor or the president. Such private assessment is an anathema to the democratic principle, apart from being open to serious objections or personal malefits. It is possible that on some rare occasions, the floor test may be impossible, although it is difficult to envisage such a situation. Even assuming that there arises one, it should be obligatory on the governor in such circumstances to state in writing the reasons for not holding the floor test. The High Court was therefore wrong in holding that the floor test was neither compulsory nor obligatory, or that it was not a prerequisite to sending the report to the president recommending action under 356(1). Since we have already referred to the recommendations of the Sarkaria Commission in this connection, it is not necessary to repeat them here. Now kindly have para 121, same page. We may, on this subject, refer to the unanimous report of the 5-member Committee of Governors, which recommended as follows. The test of confidence in the ministry should normally be left to a vote in the Assembly. Where the governor is satisfied by whatever process or means that the ministry no longer enjoys majority support, he should ask the chief minister to face the Assembly and prove his majority within the shortest possible time. If the chief minister shirks this primary responsibility and fails to comply, the governor would be in duty bound to initiate steps to form an alternative ministry. A chief minister's refusal to test his strength on the floor of the Assembly can well be interpreted as prima facie proof of his no longer enjoying the confidence of the legislature. If then an alternative ministry can be formed, which in the governor's view is able to command the majority in the Assembly, he must dismiss the ministry in power and install the alternative ministry in office. On the other hand, if no such ministry is possible, the governor will be left with no alternative but to make a report to the president under Article 356. Now kindly have para 391 on PDF page. PDF page 517. 391. 395. Yes. My lords have para 390.
Yes.
We must also say that the observations under point 7 is equally misplaced. It is true that action under Article 356 is taken on the basis of satisfaction of the Union Council of Ministers, but on that score, it cannot be said that legal malafide of the governor is irrelevant. When the article speaks of the satisfaction being formed on the basis of the governor's report, the legal malefides, if any, of the governor cannot be said to be irrelevant. The governor's report may not be conclusive, but its relevance is undeniable. Action under 356 can be based only and exclusively upon such report. Governor is a very high constitutional functionary. He is supposed to act fairly and honestly consistent with his oath. He is actually reporting against his own government. It is for this reason that the Article 356 places such implicit faith in his report. If, however, in a given case, his report is vitiated by legal malefides, it is bound to vitiate the President's action as well. Regarding the other points made in the judgment of the High Court, we must say that the High Court went wrong in law in approving and upholding the Governor's report in the action of the President under Article 356. The Governor's report is vitiated by more than one assumption totally unsustainable in law. Constitution does not create an obligation that the political party forming the ministry should necessarily have a majority in the legislature. Minority governments are not unknown. What is necessary is that the government should enjoy the confidence of the House. This aspect does not appear to have been kept in mind by the governor. Secondly, and more importantly, whether the Council of Ministers has lost the confidence of the House is not a matter to be determined by the governor or, for that matter, anywhere else except the floor of the House. The principle of democracy underlying our Constitution necessarily means that any such question should be decided on the floor of the House. The House is the place where democracy is in action. It is not for the governor to determine the said question on his own or on his own verification. This is not a matter within his subjective satisfaction. It is an objective fact capable of being established on the floor of the House. It is gratifying to note that Shri Raman, the former President of India, has affirmed this view in his Rajaji Memorial Lecture. And now kindly have para 395 on page 518. 395. The High Court, in our opinion, erred in holding that the floor test is not obligatory. If only one keeps in mind the democratic principle underlying the Constitution and the fact that it is legislative assembly that represents the will of the people and not the governor, the position would be clear beyond any doubt. In this case, it may be remembered that the Council of Ministers not only decided on April 20th, 1989 to convene the Assembly on 27th of that very month, that is within 7 days, but also offered to prepone the Assembly if the Governor so desired. It pains us to note that the Governor did not choose to act upon the said offer. Indeed, it was his duty to summon the Assembly and call upon the Chief Minister to establish that he enjoyed the confidence of the House. Not only did he not do it, but when the Council of Ministers offered to do the same, he demurred and chose instead to submit the report to the President. In the circumstances, it cannot be said that the Governor's report contained or was based upon relevant material. There could be no question of the Governor making an assessment of his own. The loss of confidence of the House was an objective fact, which could have been demonstrated one way or the other on the floor of the House. In our opinion, wherever a doubt arises whether the Council of Ministers has lost the confidence of the House, the only way of testing it is on the floor of the House, except in an extraordinary situation where, because of all pervasive violence, the Governor comes to the conclusion and records the same in his report that for reasons mentioned by him, a free vote is not possible in the House. Now kindly have, my lords, Shivraj Chauhan, which follows this.
Para 396 also there.
Yes, my lord. I just give me a minute. Just give me
397 also.
396. We make it clear that what we have said above is confined to a situation where the incumbent Chief Minister is alleged to have lost the majority support or the confidence of the House. It is not relevant to a situation arising after a general election where the Governor has to invite leader of the party commanding the majority of the single largest group to form the government. We need express no opinion regarding such a situation.
Now see para 397.
Yes. We are equally of the opinion that the High Court was in error in holding that enactment addition of 10th schedule to the Constitution has not made any difference. The very object of the 10th schedule is to prevent and discourage floor crossing and defection, which at one time had assumed alarming personal predilections. A legislator elected on the ticket of a party is bound to support that party in case of a division or vote of confidence in the House, unless he is prepared to forego his membership of the House. The 10th schedule was designed precisely to counteract horse trading. Except in the case of a split, a legislature has to support his party willy-nilly. This is the difference between the position obtained prior to and after the 10th schedule. Prior to the said amendment, a legislature could shift his loyalty from one party to the other and any number of times without imperiling his membership of the House. It was if he had a property in the office.
So here they say, actually,
Yeah.
Bomai deals with a completely different situation. Bomai was a case where the Council of Ministers had offered to summon the House, the session of the Legislative Assembly within a period of 1 week. Governor says, so sorry, I'm convinced that you have lost the confidence of the House. Therefore, you send the report to the President under Article 356. There the court holds that this course was not open to the governor. The only way to establish whether they had lost the majority of the assembly was to order a floor test. And therefore, the governor couldn't, on his own personal opinion that they had lost the majority, say that, well, I'm going to send a report to the president under 356.
So,
Second, they also make it clear that with the introduction of the 10th schedule, unless it's a case of a split, which was a position prior to the deletion of the split in 2004, the only case where you can not vote for your own party is a split. Otherwise, you're bound by the coattails of the party which is
no
brought into
difficulty.
power.
No difficulty.
So now, post 2004, with the split having gone away as a defense,
Yes.
the only other available exception is the case of a merger.
Right.
Save and except in the case of a merger, you are bound to vote for the party.
Right. No difficulty. But my lords, two things. Firstly, no doubt, as the facts, my lord, the Chief Justice summed up of Bomai. But Bomai doesn't just restrict itself to those facts. What Bomai says is the moment a support to a ministry is withdrawn, the fact is that in that case, the Chief Minister was keen to face a floor test. The governor dissolved the House and sent a report to the President. But what para 119 says is the moment a support to a ministry is withdrawn, the only option left to the governor is to conduct a floor test.
You know, if we accept this extreme proposition, very radical results will result. On the one hand, you have the 10th schedule, which is to prevent, the sin, the constitutional sin of defections. On the one hand, you say that, well, somebody who defects or causes a split is liable to a disqualification. At the same time, we say that, look, even if that person is liable to be disqualified, in the meantime, you must hold a trust vote on the floor of the House. That is why, if the antecedent reason for a floor test is based on a violation of the prescription in the 10th schedule, then holding a floor test at that stage will defeat the whole basis and purpose of the 10th schedule then.
No, my lords, may I with respect say, when your lordship firstly...
And you are legitimizing then a defection which will otherwise not permissible under the 10th schedule. That's what is happening actually.
Firstly, our case is not a case of a split at all. I am not relying on any defense at all. I am neither relying on 3, which in any case does not exist, or on merger. That's not been my case. I've right through argued that we are talking about a rival faction within the party, which is dissent and a sense of democracy within a party, and we claim that we are the Shiv Sena. And that is what comes to be decided. I'm not for a minute either relying on the defense or merger or on the split of 1/3. That's their contention. My case has never been.
But whether you are the Shiv Sena or not, can't be decided on the floor of the...
Will be decided. Of course not. Your lordships are right. Who is the political party will be decided by the Election Commission of India. And that power is vested in the ECI. And your lordships, in judgment after judgment from Sadiq Ali downward, that said that the exclusive jurisdiction, and there's a presumption of validity as far as decisions of the ECI are concerned. I come to those decisions.
On the 30th of June, there was no decision of the ECI.
No, my lords. On 30th, there was no decision of the ECI for the simple reason that if the decision will come when someone raises that issue, it will only be when a party approaches the ECI. There can't be a decision of the ECI dehors a party approaching the ECI.
Mr. Call,
The ECI,
where is the question of the party approaching the ECI for our understanding? On 30th, there was only one party. You were part of the party?
Yes.
Whether there was a faction within or without, you contested the election on the strength of a ticket given by the party, which was the original party. Then,
and I still say I'm the original party, they are the overwhelming minority.
to say, you are, as we understand, to show it within the party on the
Yes,
basis
and Absolutely right. My lady is right.
Do it in the house.
No. I'm not saying I do it in the house. That's why I'm saying floor test and majority in a political party are completely different
When
issues.
you go back to the party members to say, okay, here is a faction that we think are actually the Shiv Sena. So we are going to the party as if not just the organization, but each one who counts in the party, that makes the party to say, now we are.
So let me answer that. Let me answer that. One is, which is the rival faction within the party who should be recognized as the party under the symbols order. That's what the symbol order provides for. That can only be decided by the election commission and no one else, who represents the party and is the recognized, which faction is the recognized political party. That's one part. In the meantime, a ministry which has lost the confidence of the House cannot continue is a completely different issue for which the floor test is meant. I'm not going for a floor test in this matter to show that I'm the majority in the Shiv Sena political party. That has never been my case. Has never been my case at all. I'm going to the floor of the House to show that you, Mr. Thackeray, and the NDA government, coalition government that you lead has lost the majority because 7 independent MLAs and 34 of the 55 MLAs have no faith in you. Now they are presuming that this is only a rival faction within the legislature party and not a rival faction within the political party. Whereas you lots of time and again said you can't segregate the two. A legislature party is also an extension of the political party. In fact, for the continued recognition of a political party, the legislative presence of its MLAs and the percentage of vote it polls is a necessary ingredient for continuing recognition. Under 6A and 6B of the symbols order, and Sadiq Ali took note of it, they said for a party's continued recognition as a political party, its performance in the electoral hustings, its vote percentage, its MLAs and MPs are equally important. These are their arguments. And that is what I've been saying. You yourself, you're the judge, you're the jury, you say per se disqualified. There was a split only in the legislature party and thus nothing else needs to be done. My whole case has been it's a case of internal dissent. We are the faction which represents the Shiv Sena. That issue can only be decided by the election commission, where your lordships refused to stay those proceedings. The same argument was made. As far as the floor test is concerned, it is only restricted to the issue whether the chief minister or the ministry has the confidence of the House or not. And what does the governor do? The governor says, comes and face a floor test and you resign. Now, that was a pertinent question that day, which was put by your lordships and my lord the Chief Justice, saying that had this chief minister not resigned, one could have possibly seen what is the effect of those 39 plus 4 votes or 3 votes. Now, 2 answers to that. You remove those 39 plus 3 or 4, 42 votes. We are still through by a mile. And I prepared those charts and I'll show. You remove each of those 39 plus 3 votes, whose 42 in all, whose disqualification was pending, we were still through. In that case, that's one. Secondly, my lords, my first contention would still be, why should those 42 be deleted at all? Because let's face it, on that day, Nabam held the field. If Nabam held the field, Nabam said that as far as the speaker is concerned, he should not proceed with his with disqualification till its own case is decided. But let's take it. Let's take it, they should have been excluded. A chief minister who does not go through even with the deletion of 39 plus 3 or 39 plus 4, both for the election of the speaker and the election of the chief minister. He fails in both cases. I prepared those charts with 42, without 42. Because as your lordships rightly said, with those 42 votes, then the total strength also comes down. It can't be that you remove them and you don't remove them from the strength of the House. So whichever way you look at it, presuming for a minute, the trust was directly related, according to me, no. Manoj, in every disqualification is only a 10th schedule case. There can either be a 191-1 or a 192-2. These are only 2 cases of disqualification. One can either be for the grounds provided in 191-1 or 192-2 is 10th schedule. In 191-1, there's a procedure provided for the president, speaker, etc. In consultation with the election commission, you get disqualified. Under 191-2, when it comes to that, that's where the 10th schedule is kicked in. Now, all those judgments that your lordships have dealt with are all cases that if a disqualification is pending, the trust vote will still go through. In each of those cases, it could have been argued that if this disqualification petition had been decided, the trust vote would have been differently affected. It could have been the same argument in every case.
Bommai is lays down a normative principle that floor test is the actual test.
Yes.
It hasn't really taken into account the sequence in which the power of the governor has to be exercised in the case of defections. Bommai therefore it goes only that far. In its application, in the subsequent judgment of Shivraj Singh Chauhan, has the court given an exposition of how Bommai operates
Yes.
in the context of Shivraj Singh Chauhan?
So should I go to that, Manoj? Because I
asking you
halted.
that question.
Yes, I wanted to. I wanted
it?
to actually go to.
Because it just flags it here
Yes.
in Bommai and 396 and 397. And it says that the situation that would arise so far as the principle of Bommai is concerned in the context of 10th schedule stands on a slightly different footing. It says that far and then doesn't say anything further. The thing which needs to be seen with the advent of the 10th schedule is that power of the governor to ask for a floor test in the context of 10th schedule when it should be exercised. Because the fundamental difference is the floor test will be determined by this decision because the composition of the house will change.
Your Lordship, absolutely.
For which you have your answer is that it makes no difference on facts. And we are more on the principle.
Yes, no, Lordships are absolutely right. Even on the principle, my lords, when your Lordship said that a floor test must go on in other judgments, leave aside our case, must go on irrespective of the pendency of disqualification petitions, that was not in vacuum. Your Lordship said it in the context that mere pendency of a disqualification petition cannot impact a trust vote being conducted. That's what your Lordship said. Because in every case where a MLA is disqualified, his vote, one way or the other, whether his abstention or actual voting, would have had an impact on the trust vote. So my question is, my lord, to myself, how and in what ways? The individual facts of every case will vary on what day the letter went, what happened. But the principle, as your lordship rightly said, is that you cannot merely, because a disqualification petition is pending, prevent an MLA from voting in a trust vote. Now to say that you had the trust vote done because in the meantime your disqualification petition was pending, these are all hypothetical questions. Now then questioning the governor to say governor should not have called a floor test, what else could the governor have done, my lords?
Okay, sure, Shivraj Singh.
Yes, Shivraj Singh Chauhan. Please have. Sorry?
Judgment Compilation Volume 1.
Yes. Judgment Compilation Volume 1. PDF 1360. Please, one.
I know.
My lord. Yes, my lord, please start with para
Which volume? Which volume? Sorry.
1359.
Huh?
Judgment compilation 1.
One.
And page 13.
1359, para 16.
Yes. Everyone.
Mr. Maninder Singh, learned senior counsel.
Just one second.
What is the citation?
Yes. Mr. Maninder Singh, learned senior
One
counsel
minute.
appearing.
Yes.
Mr. Maninder Singh, learned senior counsel appeared in an application for impleadment moved on behalf of 16 members who had tendered their resignation to the Speaker, but whose resignations have not been accepted. On their behalf, Mr. Singh submitted that an elected member of a legislative assembly has an absolute right to resign by virtue of provisions of Article 190 of the Constitution. The Speaker of the Madhya Pradesh Legislative Assembly accepted the resignations tendered by 6 members who are part of the same group of 22 members within the span of 1 day, and in doing so has chosen not to make any inquiry in regard to the remaining 16 letters of resignation. Resignations and disqualifications are distinct concepts. The exercise of judicial review in regard to advice tendered by the Governor to the Chief Minister to convene a trust vote is not warranted. 16.5, in urging submission, Mr. Singh placed reliance on the decision of 3-judge bench in Srimant Bala Sahib versus Karnataka Legislative Assembly. Then 17, Dr. Abhishek Manu Singhvi, learned senior counsel appearing on behalf of the Speaker of the Madhya Pradesh Legislative Assembly, submitted that, and kindly have 17.8, my lords. The precedents of this court in regard to convening of a trust vote have arisen in the context of fresh elections held to the legislature and not in the context of a running assembly. This was the same contention raised there. Now kindly have para 60, 65 and 66.
You are right, same contention.
65 and 66. PDF page 1380.
383.
1380, my lord. Para 65. My lord, the Chief Justice has para
Yes.
65. In analyzing the observations made by the 9-judge bench in S.R. Bomai, it is pertinent to remember that the governor in that case did not call for a floor test. Rather, the governor of Karnataka sent a report to the president based on which the proclamation was issued under Article 356. The observation in S.R. Bomai can be relied on in determining whether the governor possesses the power to call for a floor test. Discerning the subsequent question of when the exercise of such power is appropriate is a distinct issue. On a perusal of the above observations in S.R. Bomai, it is evident that whether or not the Council of Ministers has lost the confidence of the House must be determined only on the floor of the House and not by the governor conducting an independent verification. Where the governor has reasons to believe that the incumbent government does not possess the support of the majority in the Legislative Assembly, the correct course of action would be for the governor to call upon the Chief Minister to face the Assembly and to establish the majority of the incumbent government within the shortest possible time. An exception to the invariable rule of testing whether the government has the Assembly's confidence on the floor of the House is envisaged only in extraordinary situations where, because of existence of all-pervasive violence, a free vote is not possible in the House. Then 66. As a matter of constitutional law, it would not be correct to proceed on the basis that constitutional authority entrusted to the governor to require the Council of Ministers to prove their majority on the floor of the House can only be exercised at the very first inception after general elections are held, and not when the governor has objective reasons to believe that the incumbent government does not command the confidence of the House. the governor is not denuded of the power to order a floor test, where on the basis of the material available to the governor, it becomes evident that the issue as to whether the government commands the confidence of the House requires to be assessed on the basis of a floor test. Undoubtedly, the purpose of entrusting such a function to the governor is not to destabilize an existing government. When the satisfaction on the basis of which governor has ordered a floor test is called into question, the decision of the governor is not immune from judicial review. The court would be justified in scrutinizing whether the governor prima facie had relevant and germane material to order a floor test to be conducted. It must be noted that the governor does not decide whether the incumbent government commands the confidence of the House. The purpose of holding a floor test in the Legislative Assembly is precisely to enable the elected representatives to determine whether the Council of Ministers commands the confidence of the House. That verification is not conducted by the governor. The decision in S.R. Bommai, in fact, held that recourse to the power under 356 was not warranted in a situation where the issue of confidence could yet be decided on the floor of the House by calling for a trust vote. Undoubtedly, in that case, it was the Chief Minister who had suggested, following a meeting of the Cabinet, that the House should be convened for the purpose of testing the majority of the Council of Ministers. The significance of the decision lies in the fact that the decision of the governor to submit a report under 356 was faulted on the ground that the floor test would have been an appropriate course of action. Now, so whether in Bommai the Chief Minister offered to face a floor test and the governor declined to do so, maybe the peculiar facts, the larger principle in Bommai or in Shivraj Singh Chauhan that your lordships have laid down, that your lordships have 66 though.
The first half of 66 exposition is that it's untrammeled to that extent.
Please, my lords.
The first half of 66, para 66 is governor's power is untrammeled, not confined to the inception.
Right. And that was the specific question posed.
See, para 71.
Very well.
Come further.
Yes.
Power of the governor.
Yes, yes. Yes. The powers which are entrusted to constitutional functionaries are not beyond the pale of judicial review. Where the exercise of the discretion by the governor to call a floor test is challenged before the court, it is not immune from judicial review. The court is entitled to determine whether in calling for the floor test, the governor did so on the basis of objective material and reasons which were relevant and germane to the exercise of the power. The exercise of such power is not intended to destabilize or displace a democratically elected government accountable to the Legislative Assembly and collectively responsible to it. The exercise of the power to call for a trust vote must be guided by the overarching consideration that the formation of satisfaction by the governor is not based on extraneous considerations. So, my lords, please read this with the observations in Bommai that no independent view of any person, including the governor, at the end of the day, he must take recourse to a floor test, because these are not his individual opinions. His individual opinions are only meant that prima facie it appears that the majority has been lost by the ministry in power. And after that, how does he determine? The court says you can't determine it on your own and say you've lost majority, thus I'm dissolving the House. The best way to do it is ask the Chief Minister concerned to face the floor test. And that Chief Minister in this matter refuses to face the floor test and resigns before that. And the only argument being made is because it could have been an empty formality and disqualification petitions are pending. Firstly, my lords, that can be no argument in law, but B, I go a step further, you exclude those 42. What happens? You still lose.
Para 72 also.
72.
72 and 73.
72 and 73, my lords?
Yeah.
72 and 73. While the Constitution recognizes that the governor does not possess a power While the Constitution recognizes that the governor does possess a power inhering in the office to monitor that the elected government continues to possess the confidence of the Legislative Assembly, this entrustment ought not to override or displace the basic responsibility of the executive to the legislature or the ability of the legislature to demand accountability of the executive arm of the state. Dr. Singhvi's submission that the governor cannot demand a trust vote except at the initial constitution of the Legislative Assembly following an election would be to unduly constrain the constitutional entrustment authority to the governor. Undoubtedly, the largest number of precedents emanating from this court have dealt with the situations where a trust vote was called at the time of the initial formation of the government following an election. One of the reasons for this may well be the prevalence of disputes at the time of the initial formation of the government in the states. But this line of precedent would not exhaust the power of the governor, nor does it suggest that the authority which is entrusted to the governor cannot be exercised once a government has been formed. Mr. So-and-so, on the other hand, accepted that there may be situations where the House is not in session, having been prorogued, and there arise circumstances leading the governor to a reasonable belief that the government has ceased to command a majority in the Legislative Assembly. This, in our view, would certainly be one of the situations where the governor would be justified in calling for a special session in the course of which the incumbent government may be required to establish that it continues to hold the confidence of the House. In a situation where the House has been summoned, following the aid and advice of the Council of Ministers, the position would be more nuanced in the sense that the remedy of a no confidence motion would be available to any segment of the legislature seeking to espouse the view that the government has ceased to command the confidence of the House. In exercising the constitutional authority to demand a trust vote, the governor must do so with circumspection in a manner that ensures the authority of the House to determine the existence or loss of confidence in the government is not undermined. Absent exigent and compelling circumstances, there is no reason for the governor to prevent ordinary legislative process of a no confidence motion from running its due course. The governor is an appointee of the president, but does not represent either a political ideology or a political view. The governor is expected to discharge the role of a constitutional statesman. The authority of the governor is not one to be exercised in aid of political dispensation, which considers an elected government of the day to be political opponent. The precise reason underlying the entrustment of the authority to the governor is the ability to stand above political conflicts and with the experience of statesmanship to wield the authority in a manner which subserves and does not detract from the strength and resilience of democratically elected legislatures and the governments in the states who are accountable to them. To act contrary to this mandate would result in the realization of the worst fears of the constitutional framers, who are cognizant that the office of the governor could potentially derail democratically elected governments, but nonetheless place trust in future generations to ensure that the government of the people, by the people, and for the people would not be denuded by those who are designed to act as its sentinels.
There are 74 also. First 4 lines.
In discharging this crucial role, it is necessary that the governor bear in mind that the purpose underlying the entrustment of the authority to require a trust vote is not to displace duly elected governments, but to intervene with caution when the circumstances which are drawn to the attention of the governor indicate a loss of majority. And that is exactly what the governor did in this case. 7 independent MLAs write to him to say we are withdrawing support. The leader of the opposition writes, 34 of the 55 MLAs, now of course 40, say that within the party, that's why I know this whole thing of split, merger, that's never our case, that's their case. To say that since there is no merger, since clause para 3 is not available, you have per se incurred the disqualification. And our case right through has been that whether we represent the political party, the Shiv Sena is the recognized political party, or you do, is a matter which the Election Commission will decide. The Speaker, my lords, if your lordships will recollect, and just
Equally in the present case, when the leader of the opposition writes to the governor could have advised the leader of the opposition, bring a motion of no confidence to the House.
Right, but my lords, nothing stops the governor. Today, we are testing the bona fides of a decision. My lords, to say that the governor opted for one option instead of the
opposition cannot duck the responsibility of summoning or placing a motion of no confidence by getting the governor to direct the convening of a trust.
My lords, may I with respect say the leader of the opposition did not get the governor to do anything. The leader of the opposition brought it to the notice of the governor. 7 independent MLAs also brought it to the notice of the governor. 34 MLAs within the party wrote to the governor to say that we will not support this ministry. And the governor, in exercise of his discretion, after amplifying his mind, satisfying himself that the conditions accepted, followed Shivraj Singh Chauhan to say that the best course of action available would be a floor test. Now, if your lordships in a 9 judges and Shivraj Singh Chauhan have said that that is the first course, you must follow that. And if the governor says, I'm following it, The only line of attack is because a disqualification petition is
What is
pending.
the objective material for the governor in this case?
One of the objective material was the moment, firstly, 7 independent MLAs, the leader of the opposition, and 34 out of the 55 MLAs say you do not enjoy.
Independent MLAs have nothing to do with the strength of the government in the house.
Yes, they do. They were part of the government.
There is absolutely no role because that applied when the government was formed.
No, my lords, they continued to support the government. Those 7 were part of they withdrew support to the government, my lords. Those 7 withdrew support to the government.
Were they holding ministerial posts?
I don't. Were they holding ministerial posts?
2 of them.
2 of them. My lords, they were part of the government. They were part of. Well, let's test it. When your lordships in para 121 of Bomai say that the governor
Remaining gave letters of support to the government during its formation.
Please, my lords.
The remaining, apart from the 2 who became ministers, did they just check it up later?
There was.
Just check it up. Check it up.
We'll check it up. My lords, please see. MLAs who are part of the government say we are withdrawing support. The leader of the opposition says he has lost support. 34 of the 55 ruling party MLAs say that we represent the real Shiv Sena. We have no faith in this coalition continuing. What is wrong? Have called for a floor test. If he had dissolved the house, if he had called someone else to form the government, dismissed the government, he's not done any of it. He's just said you come and prove your majority on the floor of the house. Their entire argument is that because a disqualification is pending, test that proposition, my lords. According to us, because we passed a resolution, they gave a disqualification notice to us. That's our case. Reverse the proposition. Suppose you want to defeat any bill, any decision on the floor of the house, the easiest thing is give disqualification notices to parties.
Now, in this context, if you see para 75 of Shivraj Singh,
yes.
Why the court there held that there was objective material before the governor. That's the kind of, just see that para 75 and 76 in the present case. So we then get some flavor of what are the circumstances in which the governor can call for a protest. Just see that para 75.
Yes, my lord. May I have your lordship's permission, Harry? In the present case, the facts which have come on record indicate that the budget session of the Legislative Assembly had been convened on the aid and advice of the Council of Ministers to commence on from 16/3/2020. The governor was intimated that 22 members owing allegiance to the INC has tendered their resignation to the Speaker of the Assembly. Copies of the resignation letters were forwarded to the governor. At this stage, the validity of these resignations had not been discerned and no decision had been made by the Speaker as to whether the resignations were voluntary or genuine. The Chief Minister subsequently tendered the advice to the governor for the removal of the 6 ministers who were ministers in the state government. On 13/3/2020, the Speaker of the Legislative Assembly issued notices of disqualification. However, on 14/3/2020, resignations of 6 members who were ministers of incumbent government were accepted by the Speaker, acting in exercise of the constitutional authority under the proviso to Article 193B. The Chief Minister, adverting to the turmoil in the state, addressed a communication to the Governor, 13/3/20, stating that the convening of the floor test would be a sure basis for resolving the conundrum. This is a strong indication that the Chief Minister himself was of the opinion that the situation in the state had cast his government's majority in doubt. However, upon the convening of the Legislative Assembly, no floor test was conducted and the House was adjourned till 26/3/2020. These facts form the basis on which the Governor advised that a floor test be conducted. Based on the resignation of the 6 ministers of the incumbent government accepted by the Speaker, the purported resignation of 16 more members belonging to the INC, and the refusal of the Chief Minister to conduct a floor test despite the House having been convened on 16/3/2020, the exercise of power by the Governor to convene the floor test cannot be regarded as constitutionally improper. Now, my lords, apply to the facts of our case. The Governor notes there is violence, they are being attacked. 34 of 55 do not support the ministry. 7 supporting independents have also withdrawn. The leader of the opposition has also written to the same extent. He doesn't dissolve. He doesn't swear in another government in power. He says you come and prove your majority. And your lordships, if have right to say that it's his duty to summon the House, and said that no governor or any other individual should form an independent opinion. Manoj and Bomai, your lordship, has said that the moment a governor starts forming in these matters and substituting his opinion to dissolve the house, instead of a floor test being ordered, it would be dangerous for democracy. I'm just testing the proposition of the other side, my lord, because it is being said or not. This material, in my respectful submission, is more than sufficient to meet the test of judicial review, because your lordships are not substituting your view for that of the governor. All that your lordships are seeing is whether the decision-making process was apt, it was not accentuated by malafide or bias in this matter, or any extraneous consideration was not taken into account. And in the given circumstances, my lords, the governor taking the requisite facts into account, the surrounding circumstances into account, comes to an informed decision that floor test should be conducted. And he orders a floor test. Now, because you feel the floor test would have led to a situation where you were unable to face the majority, then that should be the end of your government. Which government should be allowed to continue which cannot face a floor test, my lords? Irrespective of disqualifications pending or not pending, can any elected representative ever say that I want to continue in the ministry as an elected government without facing a floor test?
Now just look at the governor's letter. Can this even can this be suitable? I mean, look at para 1 and para 2. What does he say? That convenience compilation number.
I think.
That convenience compilation number. 2.
PDF 326.
Volume 2.
PDF 3.
Page 326.
Yes.
Just let's read that.
Yes, my lord, I'll read the whole thing. I'll read the whole letter.
Dear Shudhavji.
Yes. I'm in receipt of 2 letters dated 28/6/2022, which have been received at the Raj Bhavan, Mumbai. The first letter has been given by 7 independent MLAs stating that you have lost the majority on the floor of the Vidhan Sabha and requesting me to call for a special session of the Maharashtra Legislative Assembly and to direct you to prove your majority on the floor of the House. A similar letter dated so-and-so has been received from the leader of the opposition stating that you have lost the majority in the Maharashtra Legislative Assembly and a floor test for proving your majority in the Vidhan Sabha is urgently required. I'm in receipt of a resolution dated 21/6/2022 signed by 34 members of Shiv Sena Legislative Party stating that there is enormous discontent within the Shiv Sena cadre and the electorate on account of the alliance of the NCP and INC. The resolution clearly indicates that the majority members of Shiv Sena Legislature Party want to exit the alliance with NCP and INC, and to that end, they have reaffirmed the appointment of the leader of the Shiv Sena Legislature Party. I am also in receipt of a letter dated 21/6/2022 addressed by Eknath Rao Shinde to the Deputy Speaker stating that the purported appointment of one Mr. Ajay Chaudhary is illegal, having been made by 16 MLAs without notice and without quorum, and therefore the same is inoperative. A letter dated 25/6/2022 was also received by me, whereby 38 members of the Shiv Sena Legislature Party have alleged that the security provided by the state government to them and their family members have been illegally withdrawn. It is stated in the letter that various leaders of the state government are instigating the cadre to initiate violence against 38 MLAs, as a result of which the offices of some of these MLAs are vandalized. I have also been made aware that there have been grave threat to life of these 38 members and also their families. I have seen the developments through electronic and print media very closely, which substantiate the above facts. The apprehension of the MLAs is also fortified by the letter of the leader of the opposition, who has in fact provided links to videos where Mr. Sanjay Raut has openly stated that dead bodies of the MLAs will come to Mumbai and will be sent for post-mortem. Mr. Sanjay Raut in an interview given to the national TV has also said that ongoing violence is not even a trailer, but is just the warming up. Certain news articles reporting open and rather disturbing threats to 39 MLAs of Shiv Sena have also been enclosed with the letter issued by the leader of the opposition. In response to the aforesaid letter dated 25/6/2022 received by me on behalf of MLAs of the Shiv Sena, I had via communication dated 25/6/22 directed 1. The Home Secretary, Ministry of Home Affairs, Government of India; 2. The Chief Secretary to the Government of Maharashtra; and 3. The Additional Chief Secretary, Home Department, Government of Maharashtra, Director General of Police, Maharashtra State, and the Commissioner of Police, Mumbai, to provide adequate police protection to the MLAs and their families on the immediate basis. It is thus clear that a majority of Shiv Sena MLAs have given a clear indication on behalf of the Shiv Sena Legislature Party that they intend to exit from the Maharashtra Vikas Agadi government. and that you have been made aware of the same and that you're trying to win over your MLAs and cadre by means which are not democratic. I am therefore confident that you and your government had lost the trust of the House and the government is in minority. The Honorable Supreme Court of India in a range of decisions has time and again held that the governor possesses a power to monitor that the elected government continues to enjoy the confidence of the Legislative Assembly. It is therefore within my power and discretion to call for special session of the Maharashtra Legislative Assembly and direct a floor test to ascertain as to whether you enjoy the confidence of the majority in the House. My discretion is guided by the aforesaid facts. Please refer to Shivraj Singh Chauhan versus Speaker, Madhya Pradesh Legislative Assembly. Further, with a view to obviate any undemocratic method being employed, such as violence, illegitimate and unseemly political bargaining and horse trading in a quest for political power, the Honorable Supreme Court of India has consistently insisted upon convening a trust vote at the earliest date. In the aforesaid case of Shivraj Singh Chauhan, the Honorable Supreme Court has held that a trust vote in the ultimate analysis is to uphold the political accountability of the elected government. Some of the other judgments of the Honorable Supreme Court of India, which require the immediate holding of the poll test, are so and so. As per the judgment of Shivraj Singh Chauhan, where the circumstances of violence and coercion exist that would undermine a free and fair vote in the Assembly, the governor must take measures to ensure that the sanctity of the trust vote is maintained. In the present case, use of undemocratic means, such as violence and coercion to influence the vote, cannot be ruled out. The Maharashtra Legislative Assembly rules contemplate voting by a division by asking members to rise in their seats for the purpose of counting the votes. Such procedure for voting would, according to me, ensure that the members are allowed a free and fair vote in the present case. This is in line with the series of judgments delivered by the Honorable Supreme Court. Therefore, in keeping with the constitutional and democratic values and principles, as also the law laid down by Honorable Supreme Court of India and in pursuance of the powers conferred by Article 174, read with 175(2) of the Constitution, I hereby issue the following direction. A special session of the Maharashtra Vidhan Sabha be summoned on 30th 6, 2022 at 11 a.m. with the only agenda of a trust vote against the government. The business of the House shall be conducted in such a way that the speeches, if any, are concluded in a short period of time, and the trust vote is concluded on 30th 6 by 5 p.m. The voting will be conducted by members to rise in their seats for the purpose of...
The only reason really, a lot of this is completely constitutionally extraneous. The fact that, some MLAs have said that, well, their safety is in peril, that I directed as a governor that their safety should be provided. This has nothing to do on whether the government should be asked to face a trust vote. The only point which he says really is these 2 points. One, 7 MLAs have said that they don't owe allegiance to the government, and more important, the 34 MLAs have indicated that they want Shiv Sena to exit from the alliance with INC and the Maharashtra Vikas.
And not from the party, but from the coalition government. Manos, the resolution of 21/6/2022, as also this letter categorically says that there is a huge discontent within the party.
All what happens is that, once governors start this process of, intervening in a sitting house, that only sort of gives...
Manos, may I with respect say, when you...
Why not ask whoever wants to move a no confidence motion?
Manos, may I with respect, my lords, your lordships have said...
Why should a government which has been formed and in respect of which there was absolutely no disquiet just a month earlier, he asked to suddenly face a trust vote?
Manos, may I with respect say,
basis of these
Manos, for a government to lose a majority, there cannot be a cutoff date. That event in politics can occur at any time. Whether it enjoyed majority a month earlier or it loses majority a month later, with utmost humility I submit, is inconsequential. What is important is on the date when the governor applies his mind, was there a representation by the requisite number of members of the Legislative Assembly to say that we no longer have any faith in this government? Consciously on 21st of June 2022, 34 or 35 MLAs wrote to show that there is a huge discontent and discord within the party of an MVA alliance continuing. They don't say we are merging with someone else or we are splitting. They say within the party, and we do not want this government to continue. 7 independent MLAs who are part of the government, right? Now, my lords, I put a question to myself when from 9 judges to Shivraj Chauhan, your lordships has said the first duty is to summon the House. Why should that governor ask anyone to move a vote of no confidence? When your lordships have guided the governor time and again in various situations to say that the first right you must exercise as a constitutional authority is to summon the House and call for a floor test and ask the Chief Minister to prove his majority. Why should that governor exercise in discretion and say that no, because 1 month earlier there was no disquiet, today a vote of no confidence should be moved and not a floor test? And ultimately, as I respectfully submitted, your lordships are not sitting as a court of appeal. Even if your lordships feel that another course of action may have been a more appropriate course of action, the fact is, as long as what the governor does is within the constitutional principles as laid down in Gowai and Shivraj Singh Chauhan, that is good enough. Now, for a minute, leave this aside, what fell from my lords, the violence, what was happening to MLAs, exclude that. What is required is the essential ingredient for a floor test. The need for a floor test arises when there is a representation that the concerned chief minister or government has lost the confidence of the House. Now, as far as the confidence of the House is concerned, what material will the government look at? The governor look at? The governor will naturally look at the representations of various MLAs in the assembly to say that they're no longer supporting. What other material can he look at? And that is why, my lords, your lordships.
The head of the political party had not informed the governor that we are withdrawing from the alliance.
No, my lords.
The alliance still continued between the three parties. There was no intimation by the head of the political party.
Who was also the chief minister.
He had not intimated the government.
He had not intimated.
We are withdrawing from this alliance.
My lords, he need not, but if 34 out of 55 write to him to say, Manas, again, as I'm saying, he's not dealing with 10th schedule. That's a separate argument I'll come to. He is dealing with 34 out of the 55 MLAs writing to him to say, we have no faith in this government, in this chief minister. 7 independent MLAs who are part of the government say, we have no faith in this government. Leave aside the leader of the opposition for a minute. Now, my lords, when a governor takes a decision to conduct a floor test, what is the most important consideration in his mind? The most important consideration in his mind.
Mr. Call, read para 78 of the judgment.
My lords, of
Shivraj Singh Chauhan.
Just give me a moment.
The purpose what you are saying.
78. The idea underlying the trust, my lord, the Chief Justice has that.
Yeah.
The idea underlying the trust vote in the ultimate analysis is to uphold the political accountability of the elected government to the state legislature. Assertion of accountability is a mirror image of the collective responsibility of the government to the legislature. The requirement of the trust vote fulfills that purpose in the present case. The present controversy has shone a light on the often fluid allegiances of democratically elected representatives. This is a matter for their conscience, and the court expresses no opinion on the matter. However, it is important to note that in directing a trust vote, the governor does not favor a particular political party. It is inevitable that the specific timing of a trust vote may tilt the balance towards the party possessing a majority at the time of the trust vote is directed. All political parties are equally at risk of losing the support of their elected legislators, just as the legislators are at the risk of losing the vote of the electorate. This is how the system of parliamentary governance operates, and the learned senior counsel on both the sides of the disputes congenially admitted that the outcome of the trust vote is the ultimate litmus test for the legitimacy to govern. However, we note that where the evidence indicates that circumstances of violence and coercion exist, that would undermine a free and fair vote in the assembly. The governor and the court must take measures to ensure that the sanctity of the trust vote is maintained. In the circumstances as they have emerged in the case, the exercise of authority by the governor who was based on circumstances which were legitimate to the purpose of ensuring that the norm of collective responsibility is duly preserved, there existed no extraordinary circumstance for the governor to determine that a trust vote was not appropriate course of action on 16/3/2020. Now, my lords, all that I am respectfully submitting today is that merely because it will turn in favor of one or the other, your lordships deal with those issues. I put myself in the governor's position. My lord, suppose he had not held a trust vote. One of the first challenges would have been, despite a 9-judges bench, despite Shivraj Singh Chauhan, despite MLAs writing to him, why did he not hold the floor test? Where is the requirement in law, my lord, that if a governor, after due application of mind, comes to a conclusion that a trust vote ought to be held, he should nonetheless have a vote of confidence moved on the floor of the House and not go in for a floor test? Where is that requirement in law? And presuming for a minute, both options are available and he opts for one instead of the other, would that be enough for your lordships and exercise of your lordships' extraordinary jurisdiction to strike down the decision of the governor in a matter like this? That this is a decision so influenced by extraneous consideration or so biased or unfair, accentuated by malafide, that we will strike it down as a decision. It's a decision based on due representations made by MLAs
Yes.
And naturally, my lord, when these MLAs make representations, these are on political considerations.
Mr. Kaul, as your claim is not either a split or a merger, your
Yes.
claim is on the ground that you are the political party.
Right.
Now, in the information given to the governor, to what extent the information available as to you have garnered the political
Yes. So, my lord, as I,
majority, political, not the legislative majority.
my lord,
Where is that kind of a material? before
I'll
him?
just come to it, my lords.
Yes.
I'll come to
Okay,
it
take your own
tomorrow if your lordships permit.
I'm
Because
just
no, I'm very grateful. I'm very grateful that your
That's
lordships have
actually,
indicated. Yes.
in so far as the governor's decision is concerned, go by Bommai. The principle of the judicial review is confined to the question as indicated there. Material is available to him, relevant material. Then judicial review is available. The relevant material available for him to direct a floor test must be in relation to that kind of a decision that you have now garnered the political, not the legislative, but political power with respect to the party.
May I with
That material is available or not?
I'll address your lordships tomorrow on
No,
that.
in your own time.
10th schedule is where this whole argument of legislature, political party, is political party co-joined with legislature party? Was it only within the political party or within the legislature party is one part. As far as the governor in exercising his powers for a floor test is concerned, his only consideration is whether on the floor of the house, the members enjoy the requisite majority or not. And my respectful submission there to your lordships would be that there all that he has to see is that the elected representatives who constitute the total composition of the house, is there a substantial challenge to say that a large number of them are withdrawing their support to the ministry, which raises a genuine doubt in his mind to say that the majority of the ministry must be proved on the floor of the house, and which material was here. He doesn't have to embark on that exercise, which is a part of 10 schedule, political party, legislature party. All that he has to see is elected representatives, 34 of 55, 7 independent who were supporting, and as I said, exclude the leader of the opposition completely.
But Mr. Kaul, once the government is formed,
yes,
it is not open to any group of members of parliament or of the legislative assembly to say that, look, we don't want to go with this alliance. We have an alliance of 5 parties. It is not open to, say, a group of persons who owe allegiance to the dominant political party in the alliance, as in this case, the Shiv Sena was. Right? Shiv Sena had 55 as opposed to 44 of the Congress and 53 of the NCP. It's not open to any one segment of the any political party, whether it was the Shiv Sena or the NCP or the Congress, to say, we don't want to go along with this. That will ipso facto attract the disqualification provisions. You are bound by the whip, and you are bound to vote with your party so long as you are a legislator, unless there is a merger.
That's why, my lords, as I say,
on the one hand, none of them, either 15 or 20 or 25 or 30, can say to the governor that, look, we don't want to go along with the alliance. Answer is very simple. You don't want to go along with the alliance? Vote your leader out in the political party or take a decision in the political party outside. So long as you are a member of the house, you are bound by the discipline of the house. You have to vote with your political party.
So just to answer what my lord,
what they were essentially telling the governor was this: we don't want our political party to continue with this 3-party alliance of the MVA, right? We want to exit from that. Governor takes cognizance of it. Now, what he is essentially taking cognizance of is that there is a breakaway segment of this particular party. In that letter of the governor, one thing which is completely absent is your argument that we are the Shiv Sena. The entire letter is postulated on the fact that there was, out of 55, there are 34 people who want to break away from this alliance. And what is this but not a split?
Well, may I have respect say?
The governor at least was not alive to this argument at all, that, you represented the Shiv Sena.
May I
extraneous to the exercise of power.
Well, may I with respect say, that is not something.
The relevant material.
The material before the
Well, that, of course, the governor's council will
therefore, we are very careful in that those 2 paragraphs to say 22 members had resigned. They didn't defect. They said we quit the assembly. Out of them, 6 resignations were accepted by the speaker. 22 were in the same batch. The speaker went and accepted 6. He kept quiet over the 16. And Dr. Singhvi's argument was that you are trying to prevent the speaker. The floor test essentially is to buck the speaker's decision. So to which we said that, look, they were all 22 sailing together. Why did the speaker accept only 6 and leave the 16 intact? That is not a case where they split. They simply leave the house.
As I said, I
Take
haven't,
the consequences, vacate the house.
I haven't even come to the legislature party versus political party argument, because where my contention will be, A, there are two political whips appointed on the same day. As per us, we are following the mandate of the party. My Lord, the Chief Justice put a question to say that Sunday you decide to do what you want. That's not our case. On 21st of June 2022, a political whip was appointed. The question is whether my political whip or their political whip is the actual political whip. Because if my political whip is the whip, then I have not disobeyed any order at all. So when my Lord, the Chief Justice said that by just saying that you don't agree with the government, you ex facie, we've not done that. Our whip, and that is the question when this argument was raised on that day before your lordship, the lordship said, is this the rival faction? Whose whip was appointed? That's first for the EC to say which was the party, which was the faction, which was the recognized political party within. Because according to us, the faction within the party, which is the recognized faction today, was the faction which represents the political party and had appointed duly the whip. And the whip argument, when I come to, I'll show to your lordship, right through the convention of the Shiv Sena has been that the legislative party with the requisite authority of the political party appoints the whip, communicates it to the speaker. And even when the 10th schedule existed, when para 3 existed, your lordship said that the limited jurisdiction under 10th schedule of the speaker is to only see a prima facie split in the party, not embark on an independent inquiry. As far as the political party is concerned, that's the domain of the election commission. Today, it is being presumed as if I did not have the requisite political whip in my favor, that I did not represent the requisite majority within the party, and thus I have incurred. I've incurred the disqualification under the Act, under the Constitution. And my respectful submission right through has been, says who? Just because you say doesn't mean I'm disqualified. That has to be decided by an appropriate constitutional authority, which in this case, the wrong has decided in my favor in this matter. But be that as it may, you can't presume and say that you have incurred ex facie the disqualification and thus you were not entitled to right. After all, the concerned body has to decide that. According to me, I represent within it the view of the political party. Our resolution also, my lords, when your lordships put a question to me to say that this part that we are the Shiv Sena was not something which gets reflected in the speaker's letter. My lords, that letter, so I'm so sorry. The governor's letter. That very letter of the governor refers to the resolution of 21st June 2022, which I'll read out tomorrow to your lordships, which says there's an overwhelming discontent in the cadres of the party. The party does not want to continue. So it's not as if the governor just dealt with, and this is my argument which I've just presented before your lordships, the governor was cognizant of the fact that the resolution on the basis of which 34 MLAs wrote to him in turn referred to the large discord and discontent within the political party, which was because of continuing with MVA. The cause is not important. The reason is not important. The reason could be anything. There it was corruption and it was MVA. Could be anything. The fact remains is they were discontent. The fact remains is that an overwhelming part of the political party did not want to go along. Now, whether your whip represents the right wing, then my learned friend started going into when was the committee meeting held, what was, those are not that is not within the purview of the constitution mentioned today. That will be decided and is being decided by the EC. That who represents within the party the actual recognized political party. I'll even touch on those 18-7, 27-7, which are not the subject matter of this reference to your lordships.
We'll continue. We'll see the resolution which you said you want.
Yes, I will read, my lords. I'm very, very grateful, my lords. I'll continue to read.
We'll continue tomorrow morning. We'll continue tomorrow.